Greetings, everyone. Welcome back. Welcome back to follow up on this morning's excellent panel discussion on fisheries and marine biodiversity. I'm really happy to introduce our keynote presentation to kick off the afternoon by Dr. Mar Campins with the University of Barcelona, where we last held the International Wildlife Law Conference. That was quite nice to be able to all get together in person, and we look forward to doing that again soon, someday. Mar is a full professor of public international law at the University of Barcelona. Her main areas of teaching and research are EU law and European and international environmental law, with a focus on the climate change regime. She is a holder of a Jean Monnet Chair on Environmental EU Law, and was also a Fulbright Scholar and a visiting professor at the universities of Ottawa, Dalhousie, Montreal, Nova Southeastern, and Puerto Rico. And then someday, Mar, we need to get you. We need to get you to Stetson.
Okay.
We very much look forward to your presentation, which is on ITLOS's judicial interpretation of the precautionary principle within the framework of UNCLOS.
Okay. Thank you very much, Roy. Do you hear me? Yes. Do you hear me?
Yes.
Yes. Okay. Thank you.
Yes.
Okay. Thank you very much, Roy, for this introduction. Well, first of all, I would like to thank you, Roy, Erin, and everybody there for all your effort to go on with the organization of the conference in spite of the very adverse circumstances, and of course for inviting me, even in a remote way. I would love to be there, but that would be in another time. So my speech this afternoon, my topic will focus on the role of the International Tribunal of the Law of the Sea, in particular in the consolidation of the precautionary principle. Here you have the summary, excuse me, of my presentation. I would like first to introduce this International Tribunal, then I will just focus a little bit on principles of environmental law, and then I will go on the precautionary principle. First, I would like to make a very, very quick remarks about the International Tribunal of the Law of the Sea, because I guess that it's probably not one of the most known tribunals or international jurisdictions. It was created, of course, under the United Nations Convention on the Law of the Sea, the UNCLOS, and actually it was established in 1996, and this is one of the different means for the settlement of disputes that parties of the UNCLOS can choose when they decide to accept the convention. Together with, of course, the International Court of Justice and some arbitral tribunals. Just a few remarks concerning jurisdiction and competence, organization, access, and the most important point that I'm going to focus today, the interim measures. As for the competence, the tribunal has both contentious and advisory jurisdiction. For the contentious competence, contentious jurisdiction, it has this kind of competence concerning the interpretation or application of the convention of the UNCLOS, but it also has this capacity to interpret or to decide about the application of other international agreements. Up to now, there are around 12 multilateral agreements that confer jurisdiction to the International Tribunal. It can also decide about the disputes relating to the activities on the international seabed area through the Seabed Dispute Chamber. It has also competence on matters concerning its own jurisdiction, and of course it has this competence to decide about interim measures. As for the advisory competence, of course, It could decide or could give advisory opinions under the convention at the request of the Assembly or the Council of the International Civet Authority, and it can also give advisory opinions on other international or based on other international agreements. As for the organization, the International Tribunal for the Law of the Sea is composed by 21 judges, and of course it operates according to the relevant provisions of Part 11 and Part 15 of the UNCLOS. It works in different chambers. The most important one, of course, is the Civet Dispute Chambers, which also has the advisory jurisdiction, but there are also other special chambers: the Fisheries Dispute Chamber, the Marine Environment Dispute Chamber, the Maritime Delimitation Dispute Chambers, and, and other chambers may be created in an ad hoc basis. Access to the International Tribunal is one of the most relevant features. The tribunal, of course, is clearly open to the state parties, but the jurisdiction of the tribunal is also open to entities other than the state parties. That refers mostly to the international organizations, but may also allow other non-state actors to be part in a procedure under the International Tribunal. In particular, the International Authorities for the Authority for the Civet, the Civet Authority, also some legal or natural person. So this is something that contrasts with International Court of Justice, which is clearly open only to states, and also unlike the tribunals, the arbitral tribunals, which also appear to be only open to states. As for interim measures, this is an important aspect of the tribunal, which is the competence to decide about interim measures pending the establishment of an arbitral tribunal as set out on the the Convention on the Law of the Sea. In fact, the tribunal would recognize the value of the environment by allowing these interim measures that can be prescribed just for environmental reasons. If the tribunal considers that it has jurisdiction under Part 11 or Part 15 of the Convention, it may decide interim measures as it deems appropriate in the circumstances to preserve not only the rights of the disputing parties, but also to prevent serious damage to the marine environment. In fact, the cases I will be presenting today, or I will be commenting today, are all brought before the tribunal under these provisions. With regard to the cases dealt with by the tribunal, in particular from 1997 to 2016, a total of 27 cases. It's good to know that most of them are linked to problems with marine environment. In fact, the tribunal has been dealing mainly with two different types of cases. Most disputes were based on the arrest of shipping vessels for which the tribunal has a mandatory jurisdiction for a violation of a law or a regulation governing the protection or the preservation of the marine environment. The other type of cases concern the use here of the precautionary measures pending the establishment of an arbitral tribunal. So these are usually requests for interim measures in situations where preservation of damage to the marine environment was a key issue. We can also consider the cases according to their direct or indirect impact on the marine environmental protection. So we first can just comment very, very quickly on some cases in which the marine environment had a direct role. The first one of those cases is what is known by the SBT case. This is the Southern Bluefin Tuna. This is a fishing dispute between Australia and New Zealand on the one hand, and Japan on the other hand, which was decided in 1999, and which concerns the conservation of the population of the southern bluefin tuna, the SBT. Australia and New Zealand were arguing that Japan actions, in particular the launch of a unilateral fishing program, was against the multilateral measures on conservation and cooperation on the protection of this kind of fishing stocks. Those measures were, of course, the Convention on the Law of the Sea, but also the Convention for the Conservation of the Southern Bluefin Tuna of 1993. A second case concerns the conservation and sustainable exploitation of the swordfish stocks in the southeast of the Pacific. That was a dispute between Chile and the European Union regarding conservation and sustainable exploitation of these swordfish stocks in the high seas adjacent to the economic exclusive zone. This case was finally closed when the parties entered finally in an interim agreement. It also concerned the European Union obligations, so that was a kind of a different situation. One of the most important cases, it's actually what is known as the MOX Plan case. That was a dispute decided in 2001, which arises from the United Kingdom authorization to open a new MOX facility in Sellafield. The facility was designed to reprocess the nuclear fuel into a new fuel known as a mixed oxide fuel, or MOX. The Irish government said that the operation of the plant would contribute to the pollution in the Irish Sea and highlighted the potential risk associated with the transport of radioactive material to and from the plant. In this case, actually, the tribunal decided not to recognize the urgency of the situation, so it denied the interim measures requested by Ireland, but instead it taken the view of the obligation to cooperate as a fundamental principle. Another case is the land rehabilitation case, which is known as the Johor Strait. That was a dispute decided in 2003 between Malaysia and Singapore. The dispute concerned the land development activities conducted by Singapore, which would infringe not only the rights of Malaysia in and around the Johor Straits, but also it was causing serious and irreversible damage to the marine environment. In that case also, the tribunal did not recognize the urgency of the situation presented by Malaysia and called for the need of cooperation, etc. Finally, there is a last dispute in that same group, which concerns the delimitation of the maritime border in the Atlantic Ocean. That was a dispute between Ghana and Cote d'Ivoire. It was decided in 2015 by one of the special chambers, and the interim measures was made to prevent damages to the marine environment caused by oil exploration activities in this area. Then we also can find some other cases where the protection of marine environment only has an indirect role, but which are also related. Excuse me. This is the case, for instance, for the fisheries management cases, which also reflects environmental concerns. It's also the case in an indirect way for these cases concerning obligations and duties of flags and coastal states and sustainable management of fisheries. This is particularly the case of the advisory opinion that was given by the tribunal, by the chamber, on illegal, unreported, and unregulated fishing activities in 2015. There is another advisory opinion of 2011, which discuss the obligation of the states as for the exploitation of the international seabed area, which is also indirectly related. There are other cases that are not relevant for our topic today. So the tribunal has been discussing all these different cases, and the tribunal has been also considering different principles of international environmental law. Not only the precautionary principle that I will talk about that later, but also other international principles. The tribunal has been referring, for instance, to the principle of which established the obligation to protect and preserve the marine environment. It has confirmed in many cases that the obligation of states to protect and preserve the marine environment is a fundamental principle. Sustainable development is also considered by the tribunal as an established principle, in particular when the tribunal discuss about the principle or the promotion of optimal use of the oceans and the seas. Another principle to note is the principle of common but differentiated responsibilities that was dealt with in the advisory opinion of 2011 by the Seabed Dispute Chamber. And actually, the chamber decided that, of course, there is no any difference in treatment between the developing countries and developed countries on the UNCLOS, but it recognizes the need to consider whether or not sponsoring states of the activities that are undertaken in the seabed area of developing countries were given some kind of preferential treatment. Another and last principle that has been considered by the International Tribunal is the environmental impact assessment. Well, in order to require the parties in the dispute to cooperate in a prior assessment that should then maybe result on some provisional or on some interim measures. So what about the precautionary principle? How the tribunal has been considering this precautionary principle in the framework of the protection of the marine environment. Here you have the different cases in which the tribunal has considered this principle. I will referring to all those cases. The Southern Bluefin Tuna of 1999, the SBT case, the MOX Plan 2001, the case between Malaysia and Singapore, the land reclamation on the Strait of Johor, 2003, and the advisory opinion on the responsibilities and obligation of states with respect to the activities in the area of 2011. In fact, the precautionary principle or the precautionary approach, although it has been presented as a fundamental principle of international environmental law, is well known for its controversial interpretation and for its practical implications. This principle, of course, is not explicitly recognized in the Convention of the Law of the Sea, and its content and status in international law is not at all clear. Despite the balance between potential environmental damage and scientific uncertainty, it appears with different characteristics, with different value in different international instruments and different international agreements or policy documents related to the environmental protection. All these cases will be used now to discuss some of the elements that I would like to highlight, elements that have been discussed by the tribunal and which concerns the scope of the precautionary principle. First point, or first element I would like to mention is this, the recognition of the need of prudence and precaution that may justify the suspension of overfishing. That was a discussion brought in the SBT case of 1999. As I said, this is the case of Australia and New Zealand against Japan to settle the controversy about the southern bluefin tuna fishery. In view of Japan's attitude, the two states, Australia and New Zealand, requested the establishment of an arbitral tribunal in accordance with the Convention of the Law of the Sea. In addition, because they requested to mediate cessation of Japanese catches in excess of the quotas granted, those two states also requested the tribunal to take an interim measure. In that case, New Zealand and Australia were asserting that Japan was in breach of its obligations under the Convention of the Law of the Sea, as well as the Convention of 1993, with respect to the conservation and management of the southern bluefin tuna, with respect to the requirements of the precautionary principle. The request for the interim measures was based on this need for precaution, and it was unclear whether or not increased annual catches would cause irreversible damage to the stock of southern bluefin tuna in the ocean. In a decision that was rendered in August 1999, the tribunal accepted the request for interim measures and ordered that the Japanese program be immediately suspended until the arbitral tribunal had considered the merits of the case. So it ordered the suspension of overfishing on the basis of prudence and precaution to ensure the conservation of marine life. And it was the very first time that an international tribunal ordered the suspension of an activity based in the precautionary principle and in scientific uncertainty. Excuse me. The second point I want to comment is this debate between the precautionary approach or the precautionary principle that has been considered in the within the tribunal. In the SPT case, the tribunal adopted a precautionary approach in its decision of interim measures. Although it did not expressly mention the precautionary principle, the reference in its decision to the need for prudence and precaution at least indicates or gives some idea of the influence of this precautionary principle. Notwithstanding, the tribunal actually did not work at all on the concept, on the content, or on the modalities of the application. But even if the decision contains let's say, little help on that point, some individual opinions of some judges may give us some better understanding. For example, Judge Lang expressed his preference for the precautionary approach over the precautionary principle, considering that the precautionary, the idea of approach introduces certain degree of flexibility and tends to underline the reluctance to make premature statements about any kind of desirable normative structures. Judge Shearer notes also that the preference of some for the use of the term approach, in case in particular of fisheries management, rather than this concept of principle. Well, that may be because a simple application of the precautionary principle as such would lead or may lead to the cessation of all fishing activities due to the inherent scientific uncertainties. Excuse me. Judge Treves says that the precautionary principle may be seen as a logical consequence of the need to ensure that when the arbitral tribunal decides on the merits, the factual situation has not changed. So in other words, the precautionary approach seems to be inherent to the very notion of the interim measures. In another case, in the Mox Plan case, the case between Ireland and United Kingdom, Ireland asked for interim measures, demanding the immediate suspension of the United Kingdom activities at the nuclear power station, in particular to prevent the United Kingdom from discharging those radioactive waste into the Irish Sea on the basis that the measure was urgent and in any case the consequences may be very difficult to remedy. In that case, the tribunal decision of December 2001 refused to grant the interim measures requested by Ireland. In the decision, the tribunal did not recognize the Ireland request because the action had not caused serious harm to the marine environment, and Ireland was unable to prove the urgency and the gravity of the potential harm. So in fact, the decision itself contains no reference to the precautionary principle. But again, the principle was discussed on some of the separate opinions of the judges. So for instance, Judge Seckley was the only to suggest that the precautionary principle should have been applied. But for instance, Judge Treves suggested that the lack of reference to the precautionary considerations may be explained by the fact that Ireland's argument did not focus sufficiently on whether there would be an impact on the levels of the radioactivity in the Irish Sea. Well, in that sense, Judge Wolfram takes a slightly different approach, but also finds that Ireland cannot rely on the precautionary principle or the precautionary approach. He explains that provisional measures or the interim measures should not preempt a judgment on the merits and that this limitation cannot just be overridden by invoking the precautionary principle. In fact, Judge Wolfram will distinguish here from the case on the SPT, in the sense that in the SPT case, the parties had agreed that the tuna stock was in the lowest level and that was a risk, which was not the case in that MOX case. So the last two questions I want to comment is the first, the standard of proof and the threshold to demonstrate urgency and seriousness of potential harm, and the precautionary approach and the due diligence relationship. For the first one, the standard of proof. This is one of the most difficult issues in requests for interim measures. In the SPT case, in the Southern Bluefin tuna, Judge Treves has noted that in that case, the recourse or has made a recourse to the jurisprudence of the International Court of Justice when he mentioned the fact that the court had recognized the need to preserve the rights of the parties from a condition of irreparable prejudice or irreparable harm. In the same case, Judge Lang noted that the tribunal had not based its decision on the same irreparability test applied by the International Court of Justice. And actually, he considered that the criteria of gravity is unsuitable for broad application to a wide and varied range of cases. In fact, this confirms what he considers to be the tribunal position, that this kind of irreparability is not the only criteria required. In the MOPS plan case, it's a little bit more interesting in that sense, because the standard of proof required, seems to be different. This case, as I said before, was marked not as in the case of the SVT. This case was marked by a significant disagreement over the scientific evidence. So was in that case the precautionary principle relevant? Ireland argued that the precautionary principle required the United Kingdom to demonstrate that no harm would result from the discharge. But in fact, the tribunal did not directly address the relevance of the precautionary principle, holding that the prudence requires Ireland and the United Kingdom to cooperate in exchange information. This is actually the final decision of the tribunal. Only Judge Wolfram dealt with the precautionary principle in a little bit more detail. So it considered that if the tribunal had decided interim measures to prevent a serious harm to the marine environment in that case, this would only have been possible after, first, an assessment of the radioactivity of the Irish Sea, second, an analysis of the potential impact of the MOX plan, and finally, an analysis on how that impact affects Ireland rights. So Judge Wolfram certainly required of Ireland a higher standard of proof than should be applied to the request for the interim measures. So in that sense, despite the tribunal refusal to apply this principle, of course, this decision was important because it set more objective standards and rules for the use of the principle or the approach of precaution. The tribunal, in that sense, established some kind of threshold in order to invoke this precautionary approach. The harm to be prevented cannot be general and abstract. It must be identifiable and clear. And moreover, the threat must cause serious or irreversible damage to the environment, which was not proved in the Mox plant case by Ireland. So in that case, the tribunal decided that Ireland failed to meet this threshold necessary to demonstrate the urgency and denied the interim measures. My last point concerns this relationship between the precautionary approach and due diligence. That was one of the main discussions in the case on the advisory opinion on the responsibilities and obligations of states with respect to the activities in the international civet area. This advisory opinion resulted from a request from Nauru concerning the extent of the responsibilities of Nauru and other developing countries when sponsoring legal persons to undertake exploration activities in the civet area. In fact, Nauru was concerned as a developing country about whether it may face potentially obligations. This was the first judicial act, in fact, of the civet dispute chambers, which is the one which is allowed to give these advisory opinions. And here, the chamber first defined the limits of the application of the precautionary approach with regard to the exploration for polymetallic nodules on the seabed that in some way may extend beyond the area and to apply to other maritime activities. Well, the important thing here is that the tribunal pointed out that the international regulations themselves, in particular, this case was the regulations on prospecting for polymetallic nodules and for polymetallic sulfides, may specify that the precautionary approach was to be applied and taken into account on the exploration in the area. The tribunal or the chamber here made a recourse to the principle 15 of the Rio Declaration, and actually it was extremely unusual to give a judicial body the opportunity to interpret the Rio Declaration, and in particular when this tribunal has considered some kind of mandatory content of such a principle. So it gives a legal effect to that principle that was not ever given before to the principle by any other court. However, of course, we cannot lose sight of the normative path of the precautionary approach in the context of the area. The tribunal describes in a very, very succinct way this transition from soft law to a direct and binding legal obligation, or even as an emerging rule of customary international law. What the tribunal does not say or choose not to say is that actually in the mother clause that these kind of activities are decided or are organized, that kind of precautionary approach only applies to the extent possible. So this is also an important qualification that may probably put some difference between the imposition of the precautionary approach on the sponsoring the states of this kind of activities and its application to the contractors. Second, in that case, the tribunal used the precautionary principle in principle 15 of the Rio Declaration to establish somehow how and in what situations the principle may be invoked. So the tribunal said, the chamber said, it may be applied only in the case of the threat of serious or irreversible damage to the environment, as it has been said before, but also considers that the cost effectiveness of these precautionary measures that are adopted have to be analyzed. So that is, the measures to be used must have more benefits than cost. In another hand, the tribunal also refers to this principle with regard to the fact that the precautionary approach is to be adopted by the states, it says, according their capabilities. That may introduce the possibility of different uses of the precautionary approach in the light of different capabilities of each state. However, it must be clear that, as I said before, the UNCLOS does not grant any kind of preferential treatment to developing states with respect to the responsibilities of countries sponsoring activities in the area. Finally, this specific obligation to use this precautionary approach as a guiding principle for activities in the area, the tribunal has also recognized it a general duty of due diligence for states. This duty of due diligence obliges states to take all necessary measures to avoid damage that may result from any maritime activity. And of course, this obligation applies to situations where scientific evidence regarding to the extent of potential for adverse impact may be insufficient. The tribunal interpreted actually when was asked about the central question, what must the sponsoring state do to ensure that the sponsored contractor complies with its own commitments with respect to the activities on this area in regard to these precautionary principles? Well, the tribunal interprets this responsibility to ensure as a duty of due diligence closely linked to the precautionary principle. Finally, the tribunal concluded that many of the direct obligations imposed by a sponsoring state, either under the convention or in the regulation, were also part of this general duty of due diligence. So my concluding remarks. I'm sorry, I'm just out of my time. Just very few concluding remarks. Which are the main challenges and merits of the precautionary principle as it has been dealt with by the International Tribunal? Well, probably the first challenge is that the same way that the UNCLOS cannot avoid, even in these decisions from the International Tribunal, there are still some fundamental tensions, such as the relationship between the economic development, this idea of sovereignty, the exploitation of the state resources, the environmental protection, etc. Somehow these conflicting interests may undermine the effectiveness of the final decisions on the interim measures. There is another problem here which concerns, I didn't deal with that now, but it concerns to the relationship between the conventions, regional treaties, and the regulation of fishing under the UNCLOS, because actually the UNCLOS allows that the tribunal may also intervene in case that other international agreements give that competence in order to decide about or in the framework of the settlement of disputes. So the problem is sometimes this relationship between the role of the tribunal and this and the UNCLOS and these all other regional international agreements. There has been another challenge or another risk which has been very much discussed. There is some concern that the tribunal may contribute to divergent jurisprudence. So because actually the tribunal is acting at the same time or parallel to the International Court of Justice and also to the arbitral tribunals. Well, actually, the idea is that it doesn't happen, at least for the moment. And the tribunal system was designed and seeks to avoid this kind of divergent jurisprudence because it acts under the same convention of the law of the sea. Finally, what for the role of the precautionary principle? Well, the precautionary approach or the precautionary principle, as for the consideration under the International Tribunal for the Law of the Sea, is best seen as kind of a horizontal obligation that exists alongside other commitments. And while it's logical that where the strict conditions for the application of the precautionary approach are not met, environmental prerogatives always require the highest possible level of environmental protection. So the tribunal said actually that the precautionary approach is also an integral part of the general duty of due diligence. And there is no an idea to demarcate a different or lower precautionary approach. If the precautionary principle finally is considered not just as a principle or as a rule of customary law, but just as a general approach, then it's used by international tribunal, it's probably easier to explain. From this point of view, the real importance of the precautionary principle is that it may redefine the existing rules of international law on the control of environmental risk and the conservation of natural resources. It may not be longer necessary to demonstrate that significant or irreversible harm is certain or probable before referring or before requiring the appropriate preventive measures to be taken. So in general terms, I'm finishing with that, the tribunal record in that sense, and the idea is that the general activity of the tribunal may be considered quite positive, but probably it has not yet exploited the full potential of the convention or the regional conventions for the protection of the maritime for the marine protection. So maybe the cases on the tribunal does not help a lot on questions what level of risk may justify the invocation of the principle, what risk deserve priority, what kind of measures should be taken, but it may give some insights about the degrees of precaution, the idea of cost and benefit, or which are at least the core elements to take into account, the threat of a serious risk, the degree of knowledge at a given moment, the stance of timing, the need of early and anticipatory measures, etc. So just to finish, and as we are saying a lot these days now here in Spain, better safe than sorry. And probably the choice is not just between acting now and waiting, or waiting and learning and acting later, but the choice maybe today may be about acting and learning at the same time versus waiting and learning, because we have no time for that. So thank you very much.
Thank you, Mar. That was excellent. That was a great great overview and analysis of ITLO's decisions. And we have a couple of questions already. If folks do have questions, please you can type them into the question box or the chat box. And the first one that came in was from Chinti Vida Najee. And the comment question is, not sure if I missed this, but was the international environmental law principle of intergenerational equity ever considered by ITLOS, or was it just indirectly covered under the sustainable development principle?
Well, actually, the tribunal, international tribunal, has just discussed it expressly, this precautionary principle. It has also considered some other principles, as I said before, amongst them the sustainable development principle, but in a way which actually mixes the idea of an optimal use of oceans and an optimal use of fisheries, which relates to the sustainable development of fisheries.
Let's see. We have a question from Richard Cadell. Richard, do you want to ask it yourself, or would you like me to read it? Let's see if he'll unmute himself. Okay, let me read it. Hold on just a second. Get back. Okay, so Richard says, great paper and a really interesting journey through the ITLOS jurisprudence. Do you feel that ITLOS is the most environmentally activist forum for dispute resolution? Is it pushing the frontiers of environmental principles more strongly than other dispute resolution mechanisms? Very good question.
Oh, yes, absolutely. Actually, I have the feeling that ITLUS is probably one of the less known international judicial bodies, but on the other side has been one of the most active and most sensitive jurisdiction in terms of environmental protection. And actually one of the debates and some of the literature, I'm just remembering some article from Professor Boyle, for instance, or from other authors, even are discussing whether or not the ILDOS is taking this role of excessive activism in terms of the protection of environmental, the marine environment. It is also true that sometimes the tribunal itself cannot go farther than it finally goes, and the tribunal is only just deciding on interim measures. But sometimes I think it's much more interesting reading the separate opinions or the individual opinions of the judges on the tribunal. That really, I think, enlightened a lot, for the good and for the bad. But yes, I have that feeling that the tribunal is one of the most sensitive to the issue, and sometimes has also been accused of an excessive activism in that sense.
Thank you. Let's see, we also have a question from Ari. Ari, would you like to ask that yourself? Or would you like me to read that?
There I am. Yeah.
Sorry.
So thank you very much for that very interesting talk. So my question follows on naturally from Richard's question, talking of courts that have been accused of activism. I was wondering whether you have, by any chance, compared the case law of the ITLOS with the case law of the EU Court of Justice on the precautionary principle, and if so, if you've noticed any significant differences? Thank you.
Oh, well, actually, thank you very much for the question. That's actually a next step. I just started to work on the International Tribunal for the Law of the Sea, quite recently, in fact. And my first interest on the analysis was, in particular, this idea of the activism of the judges, or how the judges may just go on and be used as a motor to, or as a motor of this process. And I did not compare. I did not compare the case law of the International Tribunal with the case law of the European Court of Justice. Yet this is a next step I am just starting to do now in this research. But I have to say that the European Court of Justice actually has always taken this perception of the precautionary principle from a very different, I think, from a very different perspective, in the sense that the precautionary principle is expressly mentioned in the treaty, which is not in the UNCLOS, which is not anywhere. Well, it's in the different international agreements concerning environmental marine protection. It's considered in some of the regional agreements. Of course, it's also included in some of the fisheries management organizations. But I guess that the situation for the International Tribunal and the European Court of Justice, it's quite different. But yes, I'm sorry, I do not have to answer for the comparison. This is the next step in our research. This is also part of a project from the Spanish Minister on Biodiversity and Marine Protection, a project in which actually Roy also is a member. So this is part of this project, and this is the next step too. Thank you very much.
Thank you. Thank you for the question, Ari, and thanks again, Mar, for an excellent talk. I believe that's it for the questions now. Of course, if you have additional questions or if we overlook them, please just send them to us, and we will forward them on to Mar and to the other speakers. Thanks so much, Mar.
Okay, welcome back, everyone. I am now going to introduce the speakers for our second panel. This panel focuses on wildlife and animal welfare. Damon, if you could please turn over the controls to Sarah Levy. Sarah Levy is a graduate of the Juris Doctor and Master of Environmental Studies program offered jointly by Osgoode Hall Law School and the Faculty of Environmental Studies at York University in Toronto, Canada. Her master's research addressed the role of direct action in enforcing international marine wildlife conservation issues. Sarah is completing her articles of clerkship at the Ministry of Environment, Conservation and Parks at the Government of Ontario. Sarah's presentation will be A Tale of Two Seal Hunts, contesting the conflation of Canadian sealing activities. Sarah, thank you so much for being with us today.
Okay, thank you for the introduction, and thank you all for having me here today. So today I'm going to be discussing Canadian sealing activities. Many of you may be familiar with the Canadian commercial seal hunt that occurs annually in Atlantic Canada, as it's attracted international criticism and even economic sanction for decades. But although the Atlantic sealing industry is an entirely separate and distinct activity from the Inuit sealing that occurs in Canada's Arctic, the two practices are regarded by many as one and the same. So what I'm going to be doing today is comparing the traditional Inuit seal hunt and the commercial Atlantic seal hunt, and I'm going to be discussing the implications of the commercial sealing industry for both animal welfare and for Inuit livelihoods. So I'm going to begin this presentation basically by unpacking the distinctions between the two sealing activities and highlighting the differences in particular between the purpose, practice, and the regulations that govern these hunts. Then I'm going to go on to explore the conflation of Inuit and commercial sealing and how it's actually been a deliberate effort on the part of industry, government, and even special interest groups at various points. And through this, I'm going to be sort of exploring how the muddied dialogue on commercial and Inuit sealing has at once compromised both the survival of Inuit culture and livelihoods, and also hampered the comprehensive and humane regulation of the commercial sealing industry. So the context of reconciliation in Canada is critical to understanding the issues that I'm going to be discussing today, which is why I'm leading with this quote from Senator Murray Sinclair, who is an Indigenous senator and the chair of the Truth and Reconciliation Commission in Canada, which is a body that has been established to encourage reconciliation between Aboriginal and non-Aboriginal Canadians, and also to address the legacy of colonial violence in Canada. So as you can see from this quote, in this statement, Murray Sinclair emphasizes the connection between animal welfare and reconciliation with Indigenous people as issues that are intrinsically linked. Now, one of the key principles of the Truth and Reconciliation Commission of Canada, which the government has adopted, states that reconciliation also requires constructive action on the part of Canadians to address the legacies that have had destructive impacts on Indigenous people's culture, health, and economic prosperity. And essential to the health, culture, and economic prosperity of Canada's Inuit communities is the continuance of their traditional sealing industry. So it's important to bear this mandate and this context in mind when discussing this issue. So now I'm going to talk about the Inuit seal hunt. First, I'm going to talk about its purpose. So the hunting of marine mammals has been essential to Inuit survival and culture since time immemorial. In order to survive, the Inuit have relied heavily on marine mammals for both food and warmth, given the lack of vegetation in the Arctic. And because of the significance, the seal also holds a particular cultural importance for some Inuit communities, some of which are known, in fact, as the people of the seal, to such a point that the seal is considered sacred by some of these communities. Though Inuit sealing has occurred for thousands of years, the importance of sealing for Inuit survival has not diminished in a modern context, given that Inuit communities are located in remote areas where food insecurity is a very significant issue. But what's very critical to understand about this issue is that the Inuit seal hunt is not purely what we would call a subsistence hunt, because the sale of excess seal pelts harvested for subsistence allow the Inuit to sustain their modern hunting practices. So what this means is that the Inuit sell excess seal pelts on the international market, and the profits of this provide hunters with the means to afford gas and equipment to hunt, and therefore provide food for their communities. So it's important to recognize that the commercial component of the Inuit seal hunt is not a minor aspect of the traditional sealing industry. It's actually quite essential to it. Then in terms of the practice, so the Inuit do not hunt seal pups, as adult seals are more useful to them, given that they're a better source of food and fur. And the emphasis that the Inuit place on responsibility and stewardship is very much reflected in their sealing practices, as the Inuit method of sealing is highly individualized. So this means that the hunt occurs one seal at a time. The method is basically such that the hunter will drill a hole in the ice and then wait for the seal to come up, and then a harpoon or rifle is used to kill the seal, and they are killed in a single blow. So veterinarians have conducted studies of these practices and have agreed that this method is humane and results in a death that is relatively painless and not protracted. And in terms of scale, approximately 16,000 seals are hunted annually by the Inuit, which amounts to about 5% of the seals that are killed in Canada per year. So Inuit sealing is regulated under a distinct legal framework in Canada, because Aboriginal hunting rights are governed under Section 35 of the Constitution, and they're treated distinctly as an Aboriginal right. So what this means is that sealing quotas for First Nations and the way in which the industry is regulated are under land claim agreements in certain regions, and then in other regions the practice is community regulated. So in the Northern Territory of Nunavut, where most Inuit sealing occurs, sealing is regulated under the Nunavut Wildlife Act, which is a fairly recent piece of legislation that was enacted in 2018. And the Nunavut Wildlife Act is very interesting because in this act, the human-animal relationship that Murray Sinclair refers to in the quote that I led with is actually codified, because it explicitly recognizes that wildlife and habitat are to be managed comprehensively, since humans, animals, and plants in Nunavut are all interconnected. So in this way, the laws of the Inuit reflect the stewardship and respect for the seal in the Inuit tradition. So now to compare this practice with the commercial seal hunt that occurs on the East Coast. So as many of you are likely aware, the purpose of the commercial seal hunt is primarily for a fur harvest. And the commercial hunt is a seasonal industry that in recent years has been subsidized by the federal government in Canada due to the economic impact on the industry of trade bans. And whereas the Inuit seal hunt, does not involve the hunting of seal pups, the commercial seal hunt primarily involves the hunting of seal pups, because their fur is considered more valuable and sells for a higher price on the international market. Now, in terms of the practice, although the hunting of white coat, meaning young seals, is now technically prohibited under the regulations and was banned by the EU, the commercial hunt still involves the hunting of very young harp seals. So harp seals actually shed their white coats between 10 to 12 days of age. And what the studies have shown is that about 97% of the seals that are killed in the commercial hunt over the last 5 years have been below 1 month of age. So they can't really be considered adult seals. So these seals are so young that they haven't actually been weaned from their mothers and they're not able to swim. And what this means is that they dwell on concentrated areas on the ice, which allows sealers to slaughter multiple seals at a time. And this often means that the seals are not shot accurately and that they're not killed in a single blow. But doing so is in fact not a requirement under the regulations, which brings me to what the regulatory regime is actually like for the commercial hunt. So the process that's required under this regime is striking, checking, and bleeding. But given that ice flows in the region have become very unstable as a result of climate change, now the commercial hunt largely takes place at a distance from boats. And so the striking process often does not occur immediately, and seals often suffer a protracted death and are left on the ice and are not bled out immediately, which is what is required by the regulations but is not enforced. So the reason why this often goes unenforced in Eastern Canada is because the commercial seal hunt is not professionalized, meaning that there's no mandatory training or certification procedure, and there aren't really officers out on the ice ensuring that sealers adhere to the three-step process. And there's also no requirement to register sealing vessels, and they are not tracked. So in a study that was conducted by veterinarians of the commercial seal hunt, they found that 82% of the seals were not killed by the first bullet, and in 85% of cases, the seals were not killed in such a way that conformed to the three-step process. So in terms of the regulations, also what I want to talk about is the management plan for Atlantic seals, which you'll see listed there on the slide. And the reason why I want to draw this to everyone's attention is because this management plan is significant in that it addresses several broader objectives for the seal hunt. Those three objectives being, first, the implementation of a comprehensive animal welfare standard, second, the application of an ecosystem approach to management, and third, the consideration of Indigenous culture and livelihoods. So we see that the management plan is intending to take into account these broader concerns, but we're going to talk now about whether they have or not. So in terms of the way that Inuit and commercial sealing has been conflated, which seems ridiculous when you look at these two practices and how distinct they are in terms of the way in which they're carried out, the way they're regulated, and even in terms of geography, the main party that we can point to as being responsible for this is the government, because they've codified the conflation of these two practices in law and policy. So the Department of Fisheries and Oceans provides support for the Atlantic seal hunt on three bases that are relevant solely to the Inuit seal hunt. The first of these is that the DFO has stated that seal meat harvested in the commercial hunt is important for food security. Second, they have stated that the practice has cultural importance. And third, they have stated that First Nations have a constitutionally protected right to hunt seals. So all of this is obviously quite misleading because the Eastern seal hunts do not employ a significant number of Inuit or First Nations people, and they are primarily executed by settlers. It's also misleading because the meat from seals harvested in the commercial hunt is largely discarded, and food security is not a pressing issue in Atlantic Canada to the extent that it is in the Arctic. So given that the commercial hunt primarily benefits non-Indigenous people, it is questionable that the DFO's third justification for the seal hunt is that Aboriginal people in Canada have a constitutionally protected right to hunt seals, because this in no way provides legitimacy or sovereignty for commercial sealing. Another point that's worth noting is that the management plan also outlines the importance of commercial sealing being conducted in accordance with traditional ecological knowledge. But as I've shown, the commercial hunting practices do not, in fact, resemble Inuit ones and cannot be said to incorporate traditional knowledge in any meaningful way. So, I mean, the question becomes, why is the government doing this? And it's a strategic choice, and it's quite obvious. At a whaling conference in Iceland that was held back in 2003, Brian Roberts, who was then the senior advisor to the Ministry of Indian and Northern Affairs, stated explicitly that in order to garner support for the commercial seal hunt against animal rights activists, quote, "It is necessary to mount an equally emotionally powerful counter-appeal. This counter-appeal is based on the survival needs of Aboriginal communities, which depend upon the continuing taking of fur-bearing animals." So from that, we do see that this is a very deliberate strategy on the part of the government. And then on the part of industry, the conflation more surrounds the dialogue of appropriating the indigenous economic concerns to shield the commercial hunt from criticism, in saying that the commercial hunt is critical for Atlantic sealers' livelihoods. But the legitimacy of these claims is also questionable, given that sealing comprises less than 1% of Newfoundland's economy. It employs 1% of the population annually and only on a seasonal basis. So it's more something that's done to make extra money than is something that is a profession that sustains the livelihoods of the Atlantic sealers in the same way that it does the Inuit. And, you know, as I mentioned, the industry is now subsidized by the government. So that's worth noting as well. And then finally, special interest groups are also responsible for this conflation, more so historically than in the present day. But back in the 1970s, when commercial sealing was drawn to everyone's attention and when the very captivating images of the baby harp seal on the ice were coming to fruition, the mistake that interest groups made was that they did not make any distinction between commercial and Inuit or traditional sealing. So it's not that they were deliberately attempting to conflate the two, but the failure to distinguish between the two ended up having quite devastating effects, because the backlash that was suffered towards commercial sealing is also suffered by the Inuit. So nowadays, certain groups such as Sea Shepherd Conservation Society and PETA are now trying to dispel the myths surrounding Inuit sealing and have actually actively lobbied to have more robust exemptions for Inuit seal products within international trade bans. But on the other hand, groups like the International Fund for Animal Welfare are still failing to recognize the commercial component of the Inuit seal hunt, which contributes to the very damaging narrative that the Inuit hunt purely for subsistence, and in turn means that consumers don't recognize that their products are on the market. So the implications of this conflation and of the backlash towards commercial sealing resulted in, first of all, the 1983 European Union ban on sealskin products. So this was not an outright ban on all Canadian seal products. It was only pelts that were harvested from young seals, and there was a very clear exemption for Inuit seal products. But despite the fact that this ban really had nothing to do with the Inuit, there was a significant decline in demand for Inuit seal products, and this ended up having devastating social, cultural, and economic impacts on Inuit communities, resulting in loss of livelihood to such an extent that suicide became rampant in many communities when the ban came into effect. And then with the 2009 ban, that ban was more blanket in nature in that it banned all Canadian commercial seal products. Again, there was an exemption for the Inuit, but the exemption was somewhat more rigid than the previous exemption in that provinces would have to submit an application to become a recognized body under the Indigenous Communities exemption under the EU seal regime in order for the products to be sold. So there was an extra barrier there. And then the effect of this ban was that it had sort of re-devastated the Inuit seal market, which at this point had just begun to recover. So what was the Inuit response to this? Well, the way the Inuit have responded is not uniform in nature. Despite the ramifications of commercial sealing for Inuit sealing, some Inuit support the commercial hunt because of how anti-sealing campaigns have adversely affected them. But then at the same time, other Inuit hunters believe that this industry constitutes a wrongful appropriation of their sacred cultural practice and they're seeking to reclaim this as their uniquely protected right. So I'm going to let the voices of, the Inuit on both sides of this sort of speak for themselves here. So I've put two quotes up. So the first quote is from Arnatuk M. Tarkirk, who's an Inuit hunter, and in a letter to the Ottawa Citizen condemned the commercial seal hunt for the reasons I stated. And this is a somewhat common view in that many Inuit feel that the commercial hunt should end because the Inuit have a constitutional right to hunt seals, and Atlantic sealers cannot claim this right, but their actions in doing so are infringing on their codified rights and their ability to participate in the modern economy. But then on the other side, I've posted a quote from James Ituluk, who's vice president of Nunavut Tungavik Inc., which is an Inuit community group. And the view that he is discussing here is one that's been advanced by certain Inuit celebrities, like Tanya Tagaq, who's an Inuit throat singer, as well as the filmmakers of the documentary Angry Inuk, which was a documentary that showed the devastating collapse of the seal market. And this view is just that both seal hunts need to be supported in order for Inuit sealing to be successful and be considered okay. But again, some would say that this is a rather perverse situation of supporting a practice that would otherwise be opposed for the Inuit to be able to secure what they deserve and what they have a right to engage in. So I recognize that was a lot of information, especially for those who are not familiar with Canadian sealing practices or the Canadian regulatory regimes. So I've just posted this slide just to give a very clear breakdown of the differences between traditional sealing and commercial sealing, again, to show that they are entirely distinct. So how do we fix this is the question. Well, of course, there's an opportunity here to reform the regulations and the management plan in particular, because the management plan already has this framework in place. As I mentioned, the implementation of animal welfare standards, the application of an ecosystem-based approach, and considerations of Indigenous culture are already embedded in the framework, but right now, there only is lip service being paid to these goals. So this does present an opportunity for regulatory reform if veterinary recommendations and traditional knowledge are meaningfully incorporated in terms of sustainability, if the total allowable catches are decreased, and if there is increased monitoring and therefore compliance. And then, I mean, most critically, in terms of Inuit livelihoods, there needs to be sound information being conveyed regarding the differences between these hunts and the significance economically and culturally of them for these different groups. But the question I'll leave you with is, will regulatory solutions be enough at this point when these two different hunts have been so conflated in people's minds? I mean, the recommendations that I've outlined, they may serve to mitigate the harms that are being suffered by the harp seal, by the affected ecosystem, and by the Inuit people, but perhaps the only way to meaningfully protect the seal, the environment, and Inuit culture and their traditional hunt is to put a very clear end to the commercial hunt. And it sort of seems that the current trends are going that way, and that the commercial seal hunt's days are numbered, given again that it's not a very profitable industry anymore. But the Canadian government is continuing to prop up this industry, and for so long as they do so, it seems as though both the harp seal and the Inuit are going to continue to suffer the ramifications of that. So that's what I want to talk about today. I understand we'll be leaving questions for the end, but certainly if anybody has any questions about anything I've talked about, I'd be happy to answer them. So.
Thank you so much, Sarah. That was a really interesting presentation on the variety of interests that are involved in this issue, from sort of the animal welfare perspective, ecosystem interests, and then the various human interests that, in this particular case, are not necessarily aligned. So thank you for that, and I look forward to hearing some of the questions that folks might have for you on this case study. As you noted, we are going to save the questions till the end. So attendees, if you have a question for Sarah, please type your question in the questions section or the chat section, and then we will get to those at the end of the panel. Sarah, thank you so much for starting off this panel.
Thank you.
Our next presentation will be by Sahana Ramdas. So Damon, if you could please turn over the controls to Sahana. Sahana is working on an LLM in global environmental law at the Elizabeth Haub School of Law at Pace University in New York. Sahana earned an LLM in animal law from Lewis and Clark Law School, previously practiced in New Delhi, Bangalore, and was head legal counsel for Wildlife SOS, also in New Delhi.
Firstly, thank you all for allowing us to collectively meet and discuss wildlife and protecting them. Today I would be talking on one of my papers wherein I've mainly analyzed as to how wildlife are being categorized as vermin since many centuries and being exterminated. So mainly at this point in time, I'm just going to focus on the United States of America, and I'll be analyzing the wildlife mismanagement through sports hunting, recreational hunting, and food hunting, and which is devoid of ethics, and the ecological implications on the ecosystems. So worldwide, wildlife are categorized as invasive species, obnoxious animals, pests, and mainly as nuisance and problem animals. So before I begin, I would like to just sum up what I would be focusing on. So, in the United States, the unscientific practices of traditional wildlife management continues to expand, combined with outdated land management policies, which have contributed to the overpopulation of prey base. That is like deers and other forms of wildlife which are now being targeted. Now, despite the hunting community's efforts towards wildlife management, the population density of problem animals is continuing to soar. It's not coming down, or it may come down, but just temporarily. So my conclusion would be that hunting may stabilize the excess population on a temporary basis. However, it cannot control or regulate the growing population of invasive species or, wildlife in general. So mainly I would be doing this by firstly focusing on the history of wildlife management, and then emphasizing that despite of wildlife's capacity to self-regulate its population, because of our anthropogenic interference with ecosystems through extirpation of species, there's an abnormal increase in associated and dependent species who are consequently put on the radar and killed. So when we begin with the history of wildlife management in the United States, public hunting was predominant in the 18th and 19th century. And at the end of 20th century and 21st century, the state realized that regulated hunting laws are a necessity because several wildlife species were being exterminated, and in fact, they almost went extinct. So respective state laws combined with the Federal Lacey Act started ending market hunters from killing wildlife compulsively. So these laws help to regulate hunters and who used to mainly engage in commercial hunting. So the lurking extinction of wildlife species stipulated authorities to introduce state wildlife laws and public land laws for protecting game animals and birds in the 20th century, and by issuing the compulsory hunting licenses, permits, and issuing a regulation on the catch limits. So wildlife management started with regulated hunting in refuge establishments, game preserves, and where the wildlife used to be restocked so that they could thereafter be again hunted. This resulted in wild animals being unnaturally bred, insincerely conserved through controlled public hunting of vermin, where certain game species were abundantly maintained for recreational sports hunting. Now, this happened with the use of euphemisms. Euphemism is the use of like words and terms which will mellow down something which is unpleasant, unfavorable, or hostile. So over the last few centuries, public have bought the branding of wildlife species as problem animals, mainly because wildlife hunting is clothed in euphemisms, which has eradicated millions of wildlife species from unwelcome territories. Ever since public hunting was legalized in the United States, vested interest groups have justified their lust for killing by proclaiming hunting as a cost-effective wildlife management strategy, or a tool by proclaiming the wildlife population lend themselves to be harvested by being excess in number. So this brings us to one of the euphemisms which is mainly used, harvesting of wildlife. So two things come into play. If the wildlife cannot be harvested for their fur, for their skin, for their particles, then they're immediately killed in sports hunting, or just gunning them down. But if they could be harvested, they're preserved in game refuges and establishments, and eventually harvested, that is killed. So refuge establishments for harvesting, these so-called protected areas are nothing but recreational grounds, to practice killing target animals with practices like bow hunting, and commercially exploit the game population skin and body particles thereafter. Again, the restocking of wildlife, which I earlier mentioned, is for the benefit of interest groups. On one side, the state officials encouraged hunting amongst the public by branding wildlife as vermin, and on the other side, created safe havens for preserving the economically viable population in ranches to be only harvested in game reserves during open seasons. So this is the history of wildlife management, which is prevalent, in many parts of the world even now. Now, one of the ways they could restock and maintain game population is by predator controls. Predators were largely targeted and killed and exterminated. For example, in the 1920s, it was believed that to maintain and increase populations of game species, predators must be reduced and total vermin numbers must be held in check. Game wardens and managers of the state refuges were requested to destroy all predators they would come in contact with. Additionally, the Conservation Commission, the forerunner of the Division of Natural Resources, employed a vermin exterminator who was assigned to trap and hunt vermin full-time. In the 1930s, vermin killing contests were conducted in many counties all across the United States and resulted in the elimination of thousands of wild animals. During the 1934 to 35 fiscal year alone, 40 counties sponsored and conducted such contests, believed at that time to be beneficial. So before I go to the next slide, we all understand what trophic cascading is. It's a beneficial ecosystem service which keystone predator species lend. Trophic downgrading's cascading effect is wherein when predator species are removed from an ecosystem by local extirpation or extinction, it leads to an increase in the prey base who end up being thereafter targeted as wildlife and culled. So it's the consequences of removing large apex predators from the ecosystem. So when these kind of predator species are removed from an ecosystem, the prey base increases. So one of the examples here would be the white-tailed deer, which has had a dramatic prey population increase. They've dramatically increased in the United States, and now they've become the poster childs of causing livestock damage. Even they're also termed as invasive species. So earlier, the Colombian white-tailed deer in the 20th century was one of the first species to seek protection and get protection from the Endangered Species Act, because they at that point in time were endangered and they were nearly hunted to extinction. So they were protected under the Endangered Species Act. But with the exponential growth in the areas absent of predator controls, the US Fish and Wildlife Services downlisted the Colombian white-tailed deer in 2016, and from endangered to threatened. Now, when such relisting happens of wildlife species, they are prone to being unlawfully hunted, illegally poached, so on and so forth. So earlier to such human interventions, deer population density was naturally controlled and regulated by free-roaming predators like the bears, wolves, and mountain lions, whose population and habitats have significantly reduced in the 21st century. Legalized hunting has mainly provided an additional meat source to Americans, as seen in Texas and Vermont, where the annual deer harvest averages 450,000 animals, delivering up to 14 million pounds of boneless venison. Now, also researchers and ecologists have pointed out that non-excess deer populations foraging activities is actually very beneficial. It promotes the health of the ecosystems. It reinvigorates, and it creates forest regeneration by promoting plant diversity. So these are the kind of issues we face when we encroach upon forest lands and we exterminate predators. So now I would like to talk about the targeted and mislabeled wildlife, mainly the wolves and its predatory siblings, the coyotes, which are one of the most commonly persecuted wildlife species in the United States, as they're perceived as a threat to human livestock and humans' livelihood. Wolves are mostly a direct target and sometimes are a collateral damage to their, closely related siblings, the coyotes. Especially in the US, wolves have been listed, delisted, relisted several times, and the constant wear and tear of such selective protection under the Endangered Species Act and other laws renders them highly susceptible to extinction. Now the coyotes. So coyotes are gruesomely killed in hunting contests with guns, cyanide bombs, and all throughout the United States. Culling wolves and coyotes mostly backfires because it is ineffective in curbing livestock damage, because when these predator animals are segregated and targeted or exterminated, in fact, their complex packs could fragment and disperse, causing increased predation. Thereby, stray wolves and alienated coyotes could cause more harm, more damage to human beings and their livelihoods. Earlier, when coyotes' population was regulated by wolves, bears, and mountain lions, they played an important role in the ecosystem by maintaining a healthier food web along with their counterparts, and they kept the rodent population at bay. Moreover, research has established that white-tailed deer population decreases when coyote population increases. So we see what happens when, one of the reasons as to why the white-tailed deer population has been increasing. So I would like to talk about the USDA. USDA is ASFIS, U.S. Fish and Wildlife Services agency, and the collateral damage it's causing to the ecosystem. So this agency came into play to mitigate man-animal conflict to protect endangered species. But then it seems like their priorities are elsewhere, because they're mainly focusing on protecting human beings like farmers, livestock, and properties from wildlife encroachment or from wildlife intrusion. So at best, at this point in time, the objectives are misaligned in nature, because their wildlife management mainly involves killing millions of animals on an year-to-year basis, and these are the statistics I got from the website. So if we see, the Fish and Wildlife Service in the past few years alone included killing 2.3 million animals in 2017, 2.7 million animals in 2016, and 3.2 million in 2015. And many animals are a collateral damage because it's not the hunting or the killing practices are not target specific. It cannot be target specific. So many predator and precious wildlife are exterminated, and in fact, pets are a collateral damage. In fact, humans have also succumbed to the tactics which are used by the agency. So the Fish and Wildlife Service has continued to use abhorrent, atrocious, cruel practices in killing or curbing wildlife or reducing man-animal conflict, like lethal leg traps, lethal poisons, and weapons in managing wildlife. So these are the kind of leg traps and practices which they normally engage in. So I would just like to now focus on analyzing the ecological implications of wildlife harvest on ecosystems. I'm mainly focusing on 3 papers. So the first was harvest has the potential to cause the 3 types of genetic change: alteration of the population subdivision, loss of genetic variation, and selective genetic changes. So this paper mainly focuses on where how when keystone species are when how keystone species are targeted upon, it causes an adverse impact on the entire ecosystem. I'm just going to sum up what the paper talks about. The usual targets of harvest were and still are predatory males with the attractive features such as large antlered deer, lions with nails, elephants with tusks, stag beetles with extra long horns. So trophic hunting and selective harvesting wipe out such species with ornamental traits whose genetic health and vitality is intertwined with their ornamental features. The long-term effects of such harvesting has been removing these genes from reproductive circulation, who are best adapted to withstand environmental and climatic change variations. Hence, removing even a few of these apex predators would have far-reaching and long-lasting adverse consequences than would have been anticipated. Once these predatory species are removed from a region, it brings about adverse evolutionary changes in the ecosystem and its biodiversity, such as changing and shifting the breeding, feeding, and territorial patterns of the nearby biodiversity. The second would be one of the papers again. Ecologists have emphasized that man-made alterations have the potential to adversely reshape the ecology of harvested systems. So this particular team study has revealed that regulated hunting severely disrupted the interplay between age-specific survival and environmental factors, altered the consequences of reproductive strategies, and changed reproductive values and life expectancy in the population of the world's largest terrestrial carnivores. The last paper which I would like to rely on is Mr. Richard and his team's paper on the regulated hunting, which reshapes the life history of brown bear. Here he's given a lot of examples about how it affects and how it does not bring back the beneficial ecosystem functions which apex predators play, despite of reintroducing them, despite of bringing them back. It takes them much longer duration of time to engage in the ecosystem functions which they are known for. So, for example, hunted elk and deer, not just predators, even the prey. So, in this, one of the examples which I would like to point out to is when hunted elk and deer are brought back, they are less bold and they migrate for shorter distances. That means, they transport fewer nutrients because they do not forage around in broader landscapes, and this has an adverse effect on vegetation. I would like to conclude by saying that biological controls are a natural and a humane alternative in controlling wildlife population. Supporting predatory wildlife comeback should become a core element of wildlife conservation, as we saw in Yellowstone. Reintroduction of predators to reduce the excess prey base in mismatched areas would be a humane and sensible alternative to the indiscriminate culling of wildlife. In biological control, predators specific to the resident excess prey animals are introduced to balance and shift out the situation, their population in turn being balanced by the resulting decline of the targeted excess prey base. Hence, advocating the introduction of biological controlling predators, particularly the wolves, to restore the balance in the ecosystem is required. Managing excessive wildlife populations can address scarcity of wildlife population elsewhere by rewilding measures or by capturing problem animals from densely populated areas and relocating them in areas which need them. Other measures which we could consider and sustainably adapt are non-lethal humane methods, like translocating them, using appropriate fencing, use of sonar alarms, spraying of dingo urine, all of which are promising and sustainable and more humane in form. Yeah, that leads me to conclude with my presentation. Thank you.
Thank you so much, Sahana. This was a really interesting presentation. It makes me think back to Paul Boudreau's presentation about how the terms we use to categorize animals have important legal consequences. And so here, the way in which these different species have been categorized legally has an impact on their management and control or conservation or lack thereof. Rachel is a second-year law student at Emory University School of Law. Rachel is on Emory's International Law Review. She graduated summa cum laude from State University of New York at Geneseo. And Rachel is particularly interested in shark conservation and is going to talk to us today about curbing the global fin trade. Rachel, could you please unmute your mic if you have not done so already? We can see your screen and we can see you, but I can't hear you yet.
Okay, can you hear me now?
Yes, excellent. Thank you so much for being here.
Thank you. Okay. Okay, so I've got my screen set up here in the full mode. Can you guys see it fully, or?
Yes, we can see your screen and then we can see your video on top of it.
Okay, perfect. So hi everybody, my name is Rachel Allis, and like Erin said, I am a second-year law student at Emory in Atlanta. And I first just wanted to say thank you to everybody who set up this whole conference. I know it's definitely been rough, shifting to online. We've been doing that at school, but we really appreciate it. So thank you very much. So I wrote this paper and did some research for my school's international law review, which if anyone's not familiar with that, what that really is, it's just a journal that students are on, and you write about something that's interesting to you, and it can have any connection to international law. So you get to kind of really pick what you want to do and write about. And so I spent a semester doing some research onto this topic just because it's something that I truly care about and am passionate about. So the first thing I wanted to kind of start on is what is shark finning versus the shark fin trade? Because I noticed when I did some research, a lot of different people mix these two, and I often even actually found myself doing that because they can get intertwined a lot, and I think it's really important before I even start to kind of separate them out. So just to start off, shark finning is when you remove the shark's fins at sea and often then discard the carcass and throw it overboard, which unfortunately then causes the shark to drown because they can't swim or get any oxygen as well. So they usually die, and it's a pretty gruesome practice. And a lot of people have become aware of it in the past couple of years, and it's become a lot more popular of a thing. So, but that's not really what I'm talking about today. What I'm going to talk about is the shark fin trade. So my paper has to do with Canada and the United States and a couple other places, but for the sake of time today, I'm just going to kind of talk about Canada and the US. And so shark finning has been banned in Canada and the US, but you can still sell shark fins. Under shark finning, there's nothing to prevent someone from taking a shark, killing it on the land, and then chopping off their fins and selling it in the global fin trade. And the global fin trade right now is, it's a huge market, and it's even bigger than I think we have numbers to support and know. I know that in the global fin trade, there's about a 4 times higher biomass than the reported catch rates that we have. So it really is a problem in general and is pretty big. So just to kind of start off, I'm going to talk about the importance of sharks in general. And I'm sure a lot of people know this, but I just always like to point it out. I'm a big shark lover. So just as an ecological standpoint, sharks are apex predators, meaning that they regulate essentially the entire ocean, and they're a really big indicator of ocean health. They affect a lot of other species, and they're really important. They keep other populations in check. And on an economic standpoint too, that I think some people don't think about, is that shark ecotourism generates about $314 million every year, and about 124 million of that is just specifically in the Caribbean. And it's created over 10,000 jobs, whether it's people going out and swimming with sharks, diving, going on boats to see them, stuff like that. And it's also, if you take out sharks, there's a lot of harm to local economies, which I found, which was, I thought, really interesting, that because they're an apex predator, when you take them out from the top, you start to see effects in species below them. So for example, in North Carolina, we saw a really big decline in sharks along the eastern seaboard, which then led to a really high increase of ray populations, which then eventually led to a massive decline in scallops, which then completely demolished the scallop industry in North Carolina. So, when people think that, sharks, it's not important to keep them around. If, sometimes it's convincing to people when you bring up that can be harm to local economies. So I found that to be kind of something really interesting. So about Canada. So in 1994, Canada made it illegal to fin for shark finning in their waters. So what my paper looks at is what is going on in 2019. So these really new laws surrounding shark fins and what exactly is going on with that. So in 2019, Canada passed a new amendment which made it illegal to import or export shark fins, which was really big. A lot of people, Canada at the time was still importing, before this law came into effect, Canada was importing a good amount of shark fins into, I believe it was Vancouver. And in 2019, they made it illegal to import or export from Canada. And the whole act has been regulated under the Fisheries and Oceans Department in Canada. And, in Canada, they've set up more different offices to help ensure compliance with this. They've set up 120 new offices. But it is important, I think, to note that this amendment that Canada had, it didn't just include making it illegal to import or export shark fins. It also included a couple of other things, but that's not really too much into my paper. But the program also received a lot of funding to help enforce these different laws. So kind of did some research into that as well. So a lot of people asked why. I kind of thought to myself, well, why was there this change? We went from 1994 all the way to 2019, and in between then we had some individual provinces and cities like Toronto try to ban the sale of shark fins, and that did not go over well. There's a couple of different court cases in Ontario where they failed to ban the sale of shark fins. So I kind of thought to myself, well, why have we gone from not being able to do that to now, as Canada as a whole banning this? So I think a lot of that has to do with just awareness on the issue as well. I know when Canada came out with this new law, they actually had discussed the law and promoted it in front of a mural to a man named Rob Stewart, who had done some really interesting documentaries, notably Shark Water, into this issue. And, they have credited different documentaries as being instrumental to bringing these issues to light. So I think a lot of the reasons why people have shifted towards this now is that I think people are they're more aware that this is a problem. A lot of celebrities have come out and spoken about it, and it has become a really big hot topic. So it's pretty interesting. So to move on to the United States. So currently in the US, we have prohibited shark finning in our waters, and certain states themselves have banned the sale of shark fins, notably in California. And California put that in place, I believe it was 2011 or 2012, and they got some backlash from some different communities, and they eventually even got sued, although it still stands today. So right now in the US, what we have is different states have banned the sale of shark fins, and we don't have a federal law on it. However, though, what I did a lot of my research on is a new proposed law that will ban the sale of shark fins throughout the entire United States, which is a pretty big change from back in 2011 when individual states were passing it, and they were getting sued for doing so. So it's called the Shark Fin Elimination Act of 2019. And under that law, no person shall possess, transport, offer for sale, sell, or purchase shark fins or products containing shark fins. And the penalty for this is actually really severe. It has a civil penalty of $100,000 or the fair market value of the fins, which, just for a comparison, when California put this ban into place, the fine was $1,000. So, I mean, it's a pretty big fine. And I know it's a really contentious issue. I've talked to some people who, work in shark conservation, and I've gotten some very different opinions on whether this law will actually help or if it will do nothing. So it's kind of interesting. So I wanted to spend some time talking about the national ban, a little bit of, what I think about this. Although I do recognize, there's a lot of good arguments on both sides, and it's not really a clear-cut answer as you would hope it would be. But so with the national ban, I think it gets at the question, well, will a national ban help stop the killings? Because as most people know, we're losing about 100 million sharks a year, and it's starting to become a really big problem in general. So, and when answering the question of will a ban help stop the killing, I think then that gets at kind of a deeper question of, well, why do we kill sharks? Do we kill them for their fins? Do we kill them for their meat? You know, what is the reason we kill them? Because if you answer that we kill them for their fins, then it seems logical that a ban would help stop that. But if you say no, there are a lot of other reasons why people kill sharks. It might be for their meat. And if we put a ban on selling the fins, then it's kind of, some people argue it's wasteful to take a shark on land, use the meat of the shark and then not the fins, which is, I think, an interesting argument. So a couple of things I wanted to bring up that I found particularly interesting when looking at whether a national ban is the right way to go or not is thinking of the United States' role in the global fin trade. So the NRDC came out with a report that said that the US actually does play a much bigger role in the global fin trade than we actually think. And about half of the shark fin shipments that leave Central America are going through the United States. So when the NRDC came out with their report, they estimated in about 7 years between 591 to 701 metric tons of shark fins have passed through the U.S., which is about 1.29 million sharks. I think I'm hearing something in the background there. I'm not sure if someone's asking you a question.
We just muted. I think somebody had their mic unmuted. Sorry about that.
Oh, no worries. I wasn't sure if someone was asking me a question. So yeah, so I think the fin trade in the U.S. is a little bit bigger than people think. You know, they coined the term that the U.S. is kind of like a middleman, that we take a lot of the shipments and then bring them over to Asia. So interestingly, since I'm living in Georgia, I found that Savannah, Georgia has become really a hotspot for the fin trade, and it's become a lot bigger. Some other places to name would be the Port of LA, the Port of Oakland, Port of Honolulu, Seattle Airport, and Miami Airport. And I know recently, I want to say it was in February in Miami Airport, they found about, I think, $1 million worth of shark fins that somebody was trying to carry over. So, I mean, they are passing through these areas, I mean, for sure. So another argument that I think something's interesting to talk about is for the national ban is, will it drive the sales of shark fins more underground than they already are? Because some people have made the argument that, well, since these states have put this into place, it's just driving these sales underground more, and it's becoming more secretive, that, you know, it's not actually helping. Rather, it's just becoming harder to enforce, and that we don't know where these fins are. And to that point, though, I don't think, for me, that holds enough weight to say that we shouldn't ban this nationally, because I think we're talking here with the national ban, the fine is much higher. I mean, when you're talking $100,000 and, or even, you know, for the value of the fins, whichever of the two is higher, that's a much greater risk for people than a $1,000 fine. You know, just for some background, a pound of a shark fin can, on the open market, depending, can go from $500 to $700, some higher, some lower. That I think then when you're talking about selling that at that range for $1,000, it's not too much of a, I mean, the risk isn't as high. It's not that, you know, for a $1,000 fine, you can end up making more money selling them. But when you're talking $100,000 or more, you know, I'm not so sure if people will be willing to risk that. So I think that there's an interesting argument there. But, you know, one thing that I know that people talk about with a national ban is if we have sustainable fisheries and if they can support that. And although I think that's a really complex question and not something that I think I can really get into too much within 10 minutes. But I think there are some arguments, you know, are we sustainable at fisheries right now? And I mean, I've seen some evidence to say that our current exploitation rates are 30% higher than than sharks' natural rebound rates. So I mean, is that really sustainable is the question. And to which I would say no, but I know other people would say that, we do have sustainable shark fisheries around the world. So, but that is a topic that I think does require a lot more time to get into and more nitty-gritty details that I just don't think I'll be able to do today. But I think another thing I wanted to bring up about the national ban is the role of shark meat. So I think shark meat becomes a really big component of this part, because under this, we would allow, if we pass this act, we would allow people to, you could still kill a shark and bring it to shore and sell it, and use the meat of the shark, which again brings us to the question of, why do people kill sharks? Is it for the meat or for the fins? I would argue, in my opinion, that there is a bigger fin trade than there is for shark meat. And I know that there has been research coming out to say that that the shark meat industry is much bigger than people think, and it has been growing. However, though, I think I would push back to that to say that, I mean, yeah, I'm sure it is growing, but back a couple of years ago, the FAO came out with one of their biggest studies on the global fin trade. And as soon as they came out with that, I know Hong Kong changed their commodity codes so that you couldn't really tell if they were importing or exporting shark meat or shark fins. And the same year that they did that, the global fin trade declined by 22%, which to me doesn't really mean that we're doing a better job with the global fin trade. I think it's just people are using shark meat to hide this bigger issue. So I think there's something really interesting there, that a lot of countries, since there's been more of a global presence on this issue, that a lot of countries have started to back up a little bit and start changing the way they do things to reflect that they're, actually trading shark meat and not fins. Whereas I just don't really believe that to be true, when the global fin trade has a 4 times higher biomass than the reported catch rate. So, in general, I think there's a lot of really good arguments for both sides of this. Personally, and I do respect that people think a national ban will not be good, but I personally believe that it would be helpful. I think that it would also serve as a role for other countries to kind of start doing the same. I think we're at a point, though, where we really need to do something, though, because I think we are losing an incredible amount of sharks, and it is causing a lot of different problems. And so I think, right now, I believe that the bill has been passed in the House and is just waiting for Senate approval. But, so we're kind of just in a waiting point at the moment. But I personally believe that a national ban would be really helpful, because I believe that the root of the killing is coming from their fins and not for shark meat, as some other people believe. So, yeah, that's really, I think, all I have time for today. But if anybody has any specific questions, I would love to answer them. And thank you all very much for listening. I really appreciate it.
Thank you, Rachel, and thank you for your passion on this issue. It's a really interesting case study, and I look forward to seeing how this issue progresses over the next few years, whether the United States is able to make some positive changes on this issue. But thank you so much again for being part of the conference. At this point, we're going to turn over the controls to Kate Welch. Kate is a third-year student at Stetson University College of Law. She is planning on graduating soon. She's almost finished, and she is planning to graduate with certificates of concentration in both international law and environmental law. She is a student editor for the Journal of International Wildlife Law and Policy. And again, quick plug for Julep. I hope you all will consider submitting articles for consideration for publication in the journal. Kate is one of the awesome students who has been working on those articles. Kate is also president of the Environmental Law Society, and she's done a lot of really cool things during her time at Stetson, but the one that I will note is she spent a summer volunteering with the Wildlife Trust of India. Kate is going to talk to us about trafficked animals, the rough road to recovery and rehabilitation in the United States.
I hope everyone can hear me okay.
Yes.
Thanks to the organizers and sponsors of this conference. I greatly appreciate the opportunity to speak today. And thank you especially to Stetson and the Institute for Biodiversity Law and Policy for keeping this conference alive during this hectic time. And a brief disclaimer, this is not a law and policy heavy presentation, it's more informational. And it tries to answer the question of what happens to live trafficked animals after they're seized by authorities in the United States. Oh. Okay. I'm going to begin by talking about how animals are smuggled into the US and seized at US ports of entry, then move on to the scale of the problem, how many live animals that authorities here have to deal with, and then move on to what we do with the animals in the short term, and then how we find them their permanent homes and the challenges facing caretakers of smuggled animals. The smuggling of live animals happens several different ways. They get shipped through the mail. There are a number of commercial airlines that ship animals. DHL is not supposed to ship animals because their planes are not pressurized, but smugglers that do use DHL planes for live animals often end up having dead cargo on the other side. People also carry animals on their person. People will travel by plane with hundreds of wild birds strapped to their bodies, and this is not good. This causes the animals to become highly stressed, and they often don't survive the trip. Animals also come through checked baggage. This is an animal of snakes that were found in stereos. We had a large reptile show in Orlando, Florida last year, and this gentleman who could have legally exported these snakes to Brazil didn't have a permit, so he decided instead to hide them in these stereos, and they were wrapped up in nylon tights and hidden in stereos, and US Fish and Wildlife Service caught these snakes in an X-ray machine. So the US Fish and Wildlife Service, I'll also refer to them as FWS throughout the presentation. They have 123 wildlife inspectors that are stationed at 37 different ports of entry, but they're in charge of keeping an eye on 77 different ports of entry. So they're stretched pretty thin. They do have canine teams to assist them, and they use x-rays to view packages that are known to contain live animals. They also use viewing tubes that are like plastic or glass tubes to stick in the top of the package and view what's in there without getting too close and putting themselves in danger. I did a Freedom of Information Act request last year, and I got it a few months later. And my FOIA request is for a lot more information than I actually received from the Fish and Wildlife Service. There have been a pretty steady number of seized shipments over time in the past 20 years, but individual animals that have been seized by authorities is over 407,000. So it's a lot of animals that the Fish and Wildlife Service has to deal with. 6,600 of those animals died on arrival, which is really sad. And 40% of all live animal seizures in the United States are actually corals, which often come through Florida, especially Miami. This picture on the top left is of several corals that were rubber banded together to make them only look like one in order to be able to ship more into the country. And we also have a cobra here that was found in a chip can similar to Pringles. So authorities will make an initial determination on whether or not they should seize these live animal shipments. They will often refuse a shipment if it has dangerous animals in it, also defined by the Lacey Act as injurious species. And these species can also, this definition also includes invasive species, so species that would be injurious to the ecosystems of the United States. And refused shipments containing these types of species can go right back to the sender. And this is dangerous for the live animals in those shipments because they don't have time to rest after their long journey into the United States, and they often don't get their containers cleaned or get additional food and water. Fish and Wildlife Service doesn't want to seize animals. Resources are slim, and the government does not want to take on animals with sometimes costly and complicated care regimes. Occasionally, FWS allows people who have illegally imported animals to hold and keep them because they don't have any better facilities to handle them at the time. And in those cases, the importer is not allowed to sell the animal in the meantime. And sometimes they ended up being exported anyway. The importer is responsible for all costs of care if they are holding those animals before they are given over to the authorities. DHL, FedEx, and UPS often find thousands of mitten crabs in shipments coming from China that are shipped over here for people to eat. They're immediately re-exported back to China because they're considered injurious species, and that can be very detrimental to the crabs. Let's see. So short-term care for these animals, the Fish and Wildlife Service has a list of thousands of vendors that are located near some of these ports of entry that are qualified as approved animal care and holding facilities. These vendors charge per animal per day to hold these animals. And even if they're small animals like insects and they cost less to hold per day, oftentimes these shipments have thousands of animals in them, so that price really adds up over time. These shipments, again, have large quantities of animals, so it's really difficult for vendors to care for them all at one time. And they're held by these vendors for at least 60 days or the length of the litigation against the illegal importer. So permanent homes for these animals, sometimes the vendors that are holding them in the short term actually want to keep them and have the resources to care for them permanently, which is great. But most of the time, these animals end up in AZA accredited zoos and aquariums. And the AZA accreditation comes from the Association of Zoos and Aquariums in the United States. Fewer than 10% of the approximately 2,800 animal exhibitors licensed by the US Department of Agriculture are AZA accredited. None of the facilities shown in the Tiger King documentary on Netflix are AZA accredited, which I personally find pretty reassuring. But it is difficult to place some of these animals in zoos and aquariums because they're commonly found, like red-footed tortoises that are considered vulnerable by the IUCN that are commonly kept as pets. Zoos and aquariums don't want these turtles because they're just so common. So they're often donated to vendors that use them as a pet. This tiger cub on this slide was found at the US-Mexican border by Customs and Border Protection, and that ended up at the AZA accredited Gladys Porter Zoo in Texas. Quite a few animals end up being donated to educational outreach programs and conservation missions with similar accreditation to the AZA. In one case, a shipment of juvenile spiders that had not been declared would have had to be killed, but the FWS was able to donate them to a university where they're raised and researched by students, which was great. And the rarest outcome for these live animals is they can be repatriated back to the country of origin. And this happens when there's a very rare specialized species like a tree frog that's only found in one valley of Brazil. And then the US government can get in touch with Brazil and repatriate that animal back to Brazil. Oftentimes, because we don't know where that animal has been, we can't release it back into the wild. And that's one of the biggest issues for these animals. They don't come with chain of custody paperwork, and we don't know what diseases or parasites they've been exposed to during the time that they've been smuggled into the country. So it's rare for animals to actually be released into the wild. So again, the challenges to placements are there's just too common of species and people don't want them in their zoos or aquariums. We don't know where they've been. We don't want to expose other populations to these diseases or parasites they may have picked up along the way into the United States. There's so many animals in a shipment, nobody can care for that many. And there's no money budgeted by the FWS to take care of these animals. On the right is just a list of all of the animals that the Florida Aquarium got from FWS in 1 year alone. Includes a lot of corals, but these corals have to be quarantined for a time before they can be introduced to the exhibits in the aquarium. And after quarantine, they can sometimes put them into exhibits, or they just have too many corals to begin with, so they have to transfer them to other zoos or aquariums, which can be difficult with permitting restrictions. And there's also the cost of long-term care for all these different species. In one case, the Shed Aquarium in Chicago got 102 4-inch arapaima fish. It's a rare South American fish, and they can grow up to 10 feet or more. And fast action by the Shed Aquarium and FWS was able to save over half the fish. But they grow so large, it's difficult for one aquarium to keep them all. So they usually have to transfer those fish to sister aquariums. And the same thing happened a year later, where 90 finger-length endangered giant Thai catfish were found in shipment. And so those were also sent to shed for quarantine and eventually made their way to different zoos and aquariums, or mostly aquariums in the United States. So some takeaways from this presentation is these animals are shipped in terrible conditions, and even if they are found live by authorities and confiscated from black market smugglers, they will often die in the first couple weeks of captivity in the United States. There's no resources for long-term care, and common animals are very difficult to find homes for, especially in AZA accredited zoos and aquariums. The animals are rarely freed back into the wild. In Florida, last year we had a couple gentlemen that were tracked by the Florida Fish and Wildlife Conservation Commission. And over just about a 6-month period, they had taken 4,000 different turtles from the wild, and they were going to be sold for destinations on the international black market. There was a raid of their home just a couple hours south of Stetson's law school, and that raid turned up hundreds of turtles. Those turtles were evaluated by biologists, and 600 of them ended up being put back into the wild, which is very rare and amazing. 24 of them had to be quarantined for a while because they were sick, but they were eventually cleared and released at a later date. And half of those turtles are part of a long-term monitoring project by a conservation foundation that does research on similar turtles and has done that for a long time. So we are glad that we were able to return 600 turtles back into the wild, because that's a rare outcome. All right, thank you very much.
Thanks,
Here's some
Kate.
of my sources in the U.S. Fish and Wildlife and different aquariums all over the country. So,
and you did interviews with a lot of those people, didn't you?
I did, yeah.
Excellent, excellent. Well, thank you for telling us about this issue. I think we often hear about the legal and policy issues that are involved with wildlife trafficking itself, but we don't always think about what happens to the creatures after they've been confiscated. And so thank you for sharing that information with us. At this point, we are going to start a very brief Q&A session. We've only got about 10 minutes, so I'm going to try to get to as many questions as I can. And unfortunately, if we don't get to the questions, we'll have to save them for later, but we will send those questions on to the speakers, and hopefully they can follow up with our attendees at a later time. So if all of our panelists from this panel could please turn your video back on, but keep your microphones muted. In the meantime, hopefully you can all hear me. I see Sarah. The first question is for you from Mar. Mar has a question about whether the EU change in the seal regulation and the WTO decision and the dispute between Canada and the EU will be a definitive solution on the issues that you discussed.
I'm not sure if it's going to be, because like what I was talking about is mostly, the issue is mostly that this stems from consumers not understanding the difference between Inuit and commercial seal products. So this is a change that, you know, sort of what I was alluding to at the end of my presentation, regardless of the regulatory changes that are made, or even if there are international judgments that recognize explicitly the differences between the hunts, or let's say the exemptions for the Inuit are less strict or lifted in some way, it's not going to really rectify the situation, because when people see sealskin products, especially seeing that they come from Canada, there isn't a recognition that they could possibly be from the Inuit hunt, because the two are regarded by so many as one and the same for, you know, mostly because of the way that the government has perpetuated that idea, but also because historically groups have failed to distinguish between the two. So.
Thank you. The next question is for Rachel from Blaise Pascal. Blaise Pascal asks, except for the US and Canada, is there other domestic legislation on shark finning? And I think he's specifically looking for perhaps good examples from other countries that could be used in the United States, something similar.
Hey, yeah, so my research, I mean, I know there are, but I didn't really do any work into other countries. The only other work I did mostly was on like an international basis, what we're trying to do in the high seas, which I found, I mean, I know this isn't exactly what you asked, but I know in the high seas, what they're trying to do right now is look at, a bunch of researchers are looking at tagged sharks and using boats' AIS systems and their tracking technology to kind of see overlap as to what's going on in the high seas and like how we can best protect sharks there. Because I think the high seas are kind of a different story because obviously nobody holds title to the high seas really. So I think that's kind of an interesting thing too. But yeah, my research mostly had to do with Canada and the United States. So I'm not exactly 100% sure some other countries, but I know there are.
Thank you. A question for Kate from Volker. Are there any legal changes that occurred during the time row of the seizures that were indicated on your 8th slide?
Yeah, so starting around 2013, there were some changes in the number of seizures happening in the United States. And I'm not sure of too many specific acts. I know that the Eliminate, Neutralize, and Disrupt Wildlife Trafficking Act was passed in 2016. So that could, speak to the dip in 2016 and the next couple of years. There was also several task forces set up under the Obama administration to work more closely with international authorities to keep live wildlife from being smuggled into the United States. And I think that might have also lessened the number of live animal shipments that we confiscated here. I hope that answers the question.
Okay, a question for Sahana. You had mentioned, I think early in your presentation, that the value of the fur or meat helps determine whether a species ends up being classified as a nuisance or other type of problematic species. And I just wondered if you could elaborate on that point a bit.
Sure. So what I was getting to is that when problem animals have more of a commercial industry waiting for their products, they would not be they were not immediately hunted or killed despite of them being nuisance on animals in the nearby area. So say for example foxes or raccoons, so on and so forth, their fur or their skin would have to be harvested, so they would not kill them or hunt them immediately. They would hold on to them in refuges or in game preserves for like in an interim basis for a short duration of time, and during a particular seasons while they were being hunted, their byproducts or their particles would be sent off to the commercial industries too, like fur trading or for like now of course traditional Chinese traditional medicines use wildlife products because they're considered to have like beneficial medicinal effects. So just like that, for the clothing industry, a lot of prey as well as predator animals would be retained for a while before being harvested for their products too. I hope I answered the question. I was just talking about history. Yeah.
Thank you for that clarification. Another question for Rachel. Do you know the destination countries for the shark fins that are being confiscated in the United States, and why is the trade going through the United States?
Yeah, so majority of the fins that come through the US are going to Hong Kong. In general, Hong Kong has, I think, like 80% of the world's global fin trade going on there. But the fins that are going through the US, just as a, I know you didn't ask this, but I'm going to tell you anyway, are coming from mostly Costa Rica, Panama, Ecuador, Mexico, and Peru as well. And then mostly heading to Hong Kong, although that's not the only place. I know some of them go to Malaysia as well. But to the question about why, I think that's a good question that I don't know if I had thought of myself, really why. I mean, it could just be a geographic convenience. It could just be that the U.S. is does a lot of tries. I don't exactly know, but I think that's interesting and something I could think about.
Thank you. Follow-up question for Sahana. Toward the end of your presentation, you proposed some solutions, particularly looking at biological controls, and I thought it was interesting that the solutions seem to focus primarily on finding ways to protect these species after they've already been clarified as vermin or problematic species in some other way. Are there efforts to try to prevent these species from being classified that way in the first place?
I don't see that happening in places like the US or even in India. The moment wildlife cause any form of inconvenience to nearby human inhabitants, there are enough of exemptions allowed in the law, and in fact in the social and political policies which permit them being categorized as nuisance animals. They can immediately be say for example, while I was researching, what I learned was wolves, despite of them being highly protected under the Endangered Species Act, they could still be killed, if they're causing any form of inconvenience to livestock or to humans in and around their areas. So yes, back in India, what I did see was when wildlife were considered as vermin under Schedule 5 of the Wildlife Protection Act, a lot of animal advocates and environmental advocates opposed it. Vehemently we went against them being classified that way. But for almost like 45 days to 2 months, public, farmers, so on and so forth, were allowed to exterminate them from the problem-causing areas. So animal advocates continue trying to protect wildlife and prevent them being categorized as vermin, but the probability of that being successful in protecting them is lower than we would have wished for.
Thank you. I think that is all of the questions from our attendees. Again, if we've missed any, we will follow up with you on those afterwards. I would like to thank all of our panelists. This was a really interesting panel because we touched on topics, as mentioned in Kate, that we don't always hear a lot about, really important issues. And I enjoyed hearing sort of we will have come up with. So thank you all for your excellent presentations and for being part of it. Over to Roy.
Thanks, Aaron, and thanks as well to all the panelists. That was great.
I hope everyone can hear me okay.
Yes.
Thanks to the organizers and sponsors of this conference. I greatly appreciate the opportunity to speak today. And thank you especially to Stetson and the Institute for Biodiversity, Law and Policy for keeping this conference alive during this hectic time. And a brief disclaimer, this is not a law and policy heavy presentation, it's more informational. And it tries to answer the question of what happens to live trafficked animals after they're seized by authorities in the United States. I'm going to begin by talking about how animals are smuggled into the US and seized at US ports of entry, then move on to the scale of the problem, how many live animals that authorities here have to deal with, and then move on to what we do with the animals in the short term, and then how we find them their permanent homes and the challenges facing caretakers of smuggled animals. The smuggling of live animals happens several different ways. They get shipped through the mail. There are a number of commercial airlines that ship animals. DHL is not supposed to ship animals because their planes are not pressurized, but smugglers that do use DHL planes for live animals often end up having dead cargo on the other side. People also carry animals on their person. People will travel by plane with hundreds of wild birds strapped to their bodies, and this is not good. This causes the animals to become highly stressed, and they often don't survive the trip. Animals also come through checked baggage. This is an animal of snakes that were found in stereos, We had a large reptile show in Orlando, Florida last year, and this gentleman who could have legally exported these snakes to Brazil didn't have a permit, so he decided instead to hide them in these stereos, and they were wrapped up in nylon tights and hidden in stereos, and U.S. Fish and Wildlife Service caught these snakes in an X-ray machine. So the U.S. Fish and Wildlife Service, I'll also refer to them as FWS throughout the presentation. They have 123 wildlife inspectors that are stationed at 37 different ports of entry, but they're in charge of keeping an eye on 77 different ports of entry. So they're stretched pretty thin. They do have canine teams to assist them, and they use X-rays to view packages that are known to contain live animals. They also use viewing tubes that are like plastic or glass tubes to stick in the top of the package and view what's in there without getting too close and putting themselves in danger. I did a Freedom of Information Act request last year, and I got it a few months later. And my FOIA request is for a lot more information than I actually received from the Fish and Wildlife Service. There have been a pretty steady number of seized shipments over time in the past 20 years, but individual animals that have been seized by authorities is over 407,000. So it's a lot of animals that the Fish and Wildlife Service has to deal with. 6,600 of those animals died on arrival, which is really sad. And 40% of all live animal seizures in the United States are actually corals, which often come through Florida, especially Miami. This picture on the top left is of several corals that were rubber banded together to make them only look like one in order to be able to ship more into the country. And we also have a cobra here that was found in a chip can similar to Pringles. So authorities will make an initial determination on whether or not they should seize these live animal shipments. They will often refuse a shipment if it has dangerous animals in it, also defined by the Lacey Act as injurious species. And these species can also, this definition also includes invasive species, so species that would be injurious to the ecosystems of the United States. And refused shipments containing these types of species can go right back to the sender. And this is dangerous for the live animals in those shipments because they don't have time to rest after their long journey into the United States, and they often don't get their containers cleaned or get additional food and water. Fish and Wildlife Service doesn't want to seize animals. Resources are slim, and the government does not want to take on animals with sometimes costly and complicated care regimes. Occasionally, FWS allows people who have illegally imported animals to hold and keep them because they don't have any better facilities to handle them at the time. And in those cases, the importer is not allowed to sell the animal in the meantime. And sometimes they ended up being exported anyway. The importer is responsible for all costs of care if they are holding those animals before they are given over to the authorities. DHL, FedEx, and UPS often find thousands of mitten crabs in shipments coming from China that are shipped over here for people to eat. They're immediately re-exported back to China because they're considered injurious species, and that can be very detrimental to the crabs. Let's see. So short-term care for these animals, the Fish and Wildlife Service has a list of thousands of vendors that are located near some of these ports of entry that are qualified as approved animal care and holding facilities. These vendors charge per animal per day to hold these animals. And even if they're small animals like insects and they cost less to hold per day, oftentimes these shipments have thousands of animals in them, so that price really adds up over time. The seized shipments, again, have large quantities of animals, so it's really difficult for vendors to care for them all at one time. And they're held by these vendors for at least 60 days or the length of the litigation against the illegal importer. So permanent homes for these animals, sometimes the vendors that are holding them in the short term actually want to keep them and have the resources to care for them permanently, which is great. But most of the time, these animals end up in AZA accredited zoos and aquariums. And the AZA accreditation comes from the Association of Zoos and Aquariums in the United States. Fewer than 10% of the approximately 2,800 animal exhibitors licensed by the US Department of Agriculture are AZA accredited. None of the facilities shown in the Tiger King documentary on Netflix are AZA accredited, which I personally find pretty reassuring. But it is difficult to place some of these animals in zoos and aquariums because they're commonly found, like red-footed tortoises that are considered vulnerable by the IUCN, that are commonly kept as pets. Zoos and aquariums don't want these turtles because they're just so common. So they're often donated to vendors that use them as a pet. This tiger cub on this slide was found at the US-Mexican border by Customs and Border Protection, and that ended up at the AZA accredited Gladys Porter Zoo in Texas. Quite a few animals end up being donated to educational outreach programs and conservation missions with similar accreditation to the AZA. In one case, a shipment of juvenile spiders that had not been declared would have had to be killed, but the FWS was able to donate them to a university where they were raised and researched by students, which was great. And the rarest outcome for these live animals is they can be repatriated back to the country of origin. And this happens when there's a very rare specialized species like a tree frog that's only found in one valley of Brazil. And then the US government can get in touch with Brazil and repatriate that animal back to Brazil. Oftentimes, because we don't know where that animal has been, we can't release it back into the wild. And that's one of the biggest issues for these animals. They don't come with chain of custody paperwork, and we don't know what diseases or parasites they've been exposed to during the time that they've been smuggled into the country. So it's rare for animals to actually be released into the wild. So again, the challenges to placements are there's just too common of species and people don't want them in their zoos or aquariums. We don't know where they've been. We don't want to expose other populations to these diseases or parasites they may have picked up along the way into the United States. There's so many animals in a shipment, nobody can care for that many. And there's no money budgeted by the FWS to take care of these animals. On the right is just a list of all of the animals that the Florida Aquarium got from FWS in 1 year alone. Includes a lot of corals, but these corals have to be quarantined for a time before they can be introduced to the exhibits in the aquarium. And after quarantine, they can sometimes put them into exhibits, or they just have too many corals to begin with, so they have to transfer them to other zoos or aquariums, which can be difficult with permitting restrictions. And there's also the cost of long-term care for all of these different species. In one case, the Shed Aquarium in Chicago got 102 4-inch arapaima fish. It's a rare South American fish, and they can grow up to 10 feet or more. And fast action by the Shed Aquarium and FWS was able to save over half the fish. But they grow so large, it's difficult for one aquarium to keep them all. So they usually have to transfer those fish to sister aquariums. And the same thing happened a year later, where 90 finger-length endangered giant Thai catfish were found in shipment. And so those were also sent to Shed for quarantine and eventually made their way to different zoos and aquariums, or mostly aquariums in the United States. So some takeaways from this presentation is these animals are shipped in terrible conditions, and even if they are found live by authorities and confiscated from black market smugglers, they will often die in the first couple weeks of captivity in the United States. There's no resources for long-term care, and common animals are very difficult to find homes for, especially in AZA accredited zoos and aquariums. The animals are rarely freed back into the wild. In Florida, last year we had a couple gentlemen that were tracked by the Florida Fish and Wildlife Conservation Commission. And over just about a 6-month period, they had taken 4,000 different turtles from the wild, and they were going to be sold for destinations on the international black market. There was a raid of their home just a couple hours south of Stetson's law school, and that raid turned up hundreds of turtles. Those turtles were evaluated by biologists, and 600 of them ended up being put back into the wild, which is very rare and amazing. 24 of them had to be quarantined for a while because they were sick. but they were eventually cleared and released at a later date. And half of those turtles are part of a long-term monitoring project by a conservation foundation that does research on similar turtles and has done that for a long time. So we are glad that we were able to return 600 turtles back into the wild, because that's a rare outcome. All right, thank you very much.
Thanks,
Here's some of
Kate.
my sources from the U.S. Fish and Wildlife and different aquariums all over the country. So,
And you did interviews with a lot of those people, didn't you?
I did, yeah.
Excellent, excellent. Well, thank you for telling us about this issue. I think we often hear about the legal and policy issues that are involved with wildlife trafficking itself, but we don't always think about what happens to the creatures after they've been confiscated. And so thank you for sharing that information with us. At this point, we are going to start a very brief Q&A session. We've only got about 10 minutes, so I'm going to try to get to as many questions as I can. And unfortunately, if we don't get to the questions, we'll have to save them for later, but we will send those questions on to the speakers and hopefully they can follow up with our attendees at a later time. So if all of our panelists from this panel could please turn your video back on, but keep your microphones muted. In the meantime, hopefully you can all hear me. I see Sarah. The first question is for you from Mar. Mar has a question about whether the EU change in the seal regulation and the WTO decision and the dispute between Canada and the EU will be a definitive solution on the issues that you discussed.
I'm not sure if it's going to be, because like what I was talking about is mostly, the issue is mostly that this stems from consumers not understanding the difference between Inuit and commercial seal products. So this is a change that, you know, sort of what I was alluding to at the end of my presentation, regardless of the regulatory changes that are made, or even if there are international judgments that recognize explicitly the differences between the hunts, or let's say the exemptions for the Inuit are less strict or lifted in some way, it's not going to really rectify the situation, because when people see sealskin products, especially seeing that they come from Canada, there isn't a recognition that they could possibly be from the Inuit hunt, because the two are regarded by so many as one and the same for, you know, mostly because of the way that the government has perpetuated that idea, but also because historically groups have failed to distinguish between the two. So.
Thank you. The next question is for Rachel from Blaise Pascal. Blaise Pascal asks, except for the US and Canada, is there other domestic legislation on shark finning? And I think he's specifically looking for perhaps good examples from other countries that could be used in the United States, something similar.
Hey, yeah, so my research, I mean, I know there are, but I didn't really do any work into other countries. The only other work I did mostly was on like an international basis, what we're trying to do in the high seas, which I found, I mean, I know this isn't exactly what you asked, but I know in the high seas, what they're trying to do right now is look at, a bunch of researchers are looking at tagged sharks and using boats' AIS systems and their tracking technology to kind of see overlap as to what's going on in the high seas and like how we can best protect sharks there. Because I think the high seas are kind of a different story, because obviously nobody holds title to the high seas really. So I think that's kind of an interesting thing too. But yeah, my research mostly had to do with Canada and the United States. So I'm not exactly 100% sure of some other countries, but I know there are.
Thank you. A question for Kate from Volker. Are there any legal changes that occurred during the time row of the seizures that were indicated on your 8th slide?
Yeah, so starting around 2013, there were some changes in the number of seizures happening in the United States. And I'm not sure of too many specific acts. I know that the Eliminate, Neutralize, and Disrupt Wildlife Trafficking Act was passed in 2016. So that could, you know, speak to the dip in 2016 and the next couple of years. There was also several task forces set up under the Obama administration to work more closely with international authorities to keep live wildlife from being smuggled into the United States. And I think that might have also lessened the number of live animal shipments that we confiscated here. I hope that answers the question.
Okay, a question for Sahana. You had mentioned, I think early in your presentation, that the value of the fur or meat helps determine whether a species ends up being classified as a nuisance or other type of problematic species. And I just wondered if you could elaborate on that point a bit.
Sure. So what I was getting to is that when problem animals have more of a commercial industry waiting for their products, they would not be, they were not immediately hunted or killed, despite of them being nuisance on animals in the nearby area. So say, for example, foxes or raccoons, so on and so forth, their fur or their skin would have to be harvested. So they would not kill them or hunt them immediately. They would hold on to them in refuges or in game preserves for like in an interim basis for a short duration of time. And during a particular seasons, while they were being hunted, their byproducts or their particles would be sent off to the commercial industries too, like fur trading or for like now, of course, traditional Chinese traditional medicines use wildlife products because they're considered to have like beneficial medicinal effects. So just like that, for the clothing industry, a lot of prey as well as predator animals would be retained for a while before being harvested for their products too. I hope I answered the question. I was just talking about history. Yeah.
Thank you for that clarification. Another question for Rachel. Do you know the destination countries for the shark fins that are being confiscated in the United States, and why is the trade going through the United States?
Yeah, so majority of the fins that come through the US are going to Hong Kong. In general, Hong Kong has, I think, like 80% of the world's global fin trade going on there. But the fins that are going through the US, just as a, I know you didn't ask this, but I'm going to tell you anyway, are coming from mostly Costa Rica, Panama, Ecuador, Mexico, and Peru as well. And then mostly heading to Hong Kong, although that's not the only place. I know some of them go to Malaysia as well. But to the question about why, I think that's a good question that I don't know if I had thought of myself, really why. I mean, it could just be a geographic convenience. It could just be that the US is kind of does a lot of trade. I don't exactly know, but I think that's interesting and something I could think about.
Thank you. Follow-up question for Sahana. Toward the end of your presentation, you proposed some solutions, particularly looking at biological controls, and I thought it was interesting that the solutions seem to focus primarily on finding ways to protect these species after they've already been clarified as vermin or problematic species in some other way. Are there efforts to try to prevent these species from being classified that way in the first place?
I don't see that happening in places like the US or even in India. The moment wildlife cause any form of inconvenience to nearby human inhabitants, there are enough of exemptions allowed in the law and in fact in the social and political policies which permit them being categorized as nuisance animals. They can immediately be like say for example, while I was researching, what I learned was wolves, despite of them being highly protected under the Endangered Species Act, they could still be killed. if they're causing any form of inconvenience to livestock or to humans in and around their areas. So yes, back in India, what I did see was when wildlife were considered as vermin under Schedule 5 of the Wildlife Protection Act, a lot of animal advocates and environmental advocates opposed it. Vehemently we went against them being classified that way. But for almost like 45 days to 2 months, public farmers, so on and so forth, were allowed to exterminate them from the problem-causing areas. So animal advocates continue trying to protect wildlife and prevent them being categorized as vermin, but the probability of that being successful in protecting them is lower than we would have wished for.
Thank you. I think that is all of the questions from our attendees. Again, if we've missed any, we will follow up with you on those afterwards. I would like to thank all of our panelists. This was a really interesting panel because we touched on topics, as mentioned in Kate, that we don't always hear a lot about, really important issues. And I enjoyed hearing sort of the you will have come up with. So thank you all for your excellent presentations and for being part of it. Over to Roy.
Thanks, Aaron, and thanks as well to all the panelists. That was great. All right, welcome back, everyone, for our final panel, and then we have a couple of special speakers. And our panel 3 is on challenges with invasive species and other wildlife. And due to a variety of issues, we're down to 2 speakers, but that actually works out quite well, as that's how much time we have for the speakers. So first, we're going to hear from Professor Volker Mauhofer, who is with Mid Sweden University, is a professor and chair in environmental science with a specialization in social science. A few highlights from the CV include being a coordinating lead author of the UN IPBES Global Assessment, Chapter 6, editor of the international journal Ecological Economics, co-author of more than 120 peer-reviewed publications, and has conducted freelance research over 25 years in more than 55 countries. Really delighted, Volker, that you could join us today to talk about your take on invasive alien species.
Yeah, thank you very much for having me with you today. It's the presentation latest in the day I ever gave, I think, but I'm happy to do it. And I try to get the screen big. Oh, wait. Here we go. Yeah, actually, I submitted a presentation which is based on a particular work which I did together with my graduate student Yasmina Roman. So you see her here also. She's our first in the row of authors, which I always do if I do work together with graduate students. It's about challenges and solutions for the national implementation of a supranational environmental regulation against invasive alien species. And I put here in the presentation now the focus on cooperation and coordination issues. You see here outline of my presentation. It's on we have first introduction, research goal, overview, methodology, results, particular transnational issues and national issues, conclusions. This is just a very small picture out of a larger publication, which I will show at the end. Okay, introduction and research goal. We have international environmental agreements, which are increasingly important for action against worldwide challenges towards sustainable development and environmental protection. And invasive alien species are increasingly identified as a global threat also to humans and other species. So coordination and cooperation are necessary topics to strengthen in this context. We have the international and the national subnational level, and we have all those agreements where countries have to transnationally and intranationally to cooperate and coordinate. Just on cooperation and coordination, just some brief definitions. Cooperation is a voluntary collective efforts of involved stakeholders working together to achieve common objectives. So it's quite loose, it's really voluntary. With coordination, we have more intentional, we have a more formal action in the pursuit of a common purpose. And the study aims to assess the importance of national and international, transnational cooperation and coordination for the implementation of a supranational regulation against invasive alien species, namely the EU Invasive Alien Species Regulation. Just on the EU, for those who come from other continents, 1957 founded. In 2019, we had still 28 member states, now it's 27. Own large legal framework binding for the member states in particular. We have enforcing mechanisms, and we have a certain number of legal instruments covering by enforcing mechanisms. Our study is covering particular 2 member states of the European Union, Austria and Romania. Austria is 3 times smaller than Romania, also in the size of the population. Austria is quite federal organized in terms of issues related to invasive alien species. So we have 9 different conservation laws. Romania is very central organized, and we did particular comparison between the 2 countries. So this is the Invasive Alien Species Regulation, IAS regulation, released 2014, and it aims to prevent serious adverse impact on biodiversity and related ecosystem services, as well as other social economic impact. It addresses about 12,000 invasive alien species, or alien species, and 10 to 15% of them are invasive. It's a regulation, therefore it's automatically enforceable in the EU member states. So the member states do not have, for most of the regulation norms, to release own laws or own legal norms, but the regulation is law of the member states automatically. But the invasive alien species regulation requires some additional measures or gives the opportunity to do some additional measures. Yeah, the right one you know also in the US and in Canada. And left, it's a dragonfly which is protected under EU law, but it sits on one of the most invasive plants in Europe. It comes from Asia. We applied 3 main methods. Our in-depth literature review. We did interviews, and the third methods were questionnaires. Actually, there were more questionnaires filled out than interviews held. They were completed by a wide range of stakeholders, and the respondents came from the national and from the subnational government, as well as NGOs, and from the 2 member states of the EU which I mentioned. The one is federally organized, the other one centrally. That's just the overview on the respondents. AT means Austria, RO Romania. Surveys were in total 47, and 16 in Austria, 31 about in Romania. Interviews 8 in Austria, 14 in Romania. And then there's also status as organization or NGO, if some organization is national, subnational, or NGO. 26 national respondees, 19 from subnational, 14 from subnational level, and 9 from NGO level. That's just how often, and I don't want you to read the details, but how often is cooperation and coordination are mentioned in the regulation. So 11 times the regulation speaks about cooperation, and 9 times are about coordination in partly different, partly the same context. And it refers to it on the national level, on the transnational level, or on both levels. It's the last right column of this table. So one of the questions was, for example, should Austria and Romania participate in regional and national lists? So the regulation allows to put up regional or national lists of invasive alien species. And these are voluntary instruments. So the member states do not have to do them, but they could collaborate here. And so we had as answers, yes, rather no, no, or not specified. And the answers were actually, so both the regional lists or the national lists are both voluntary, and are actually here we found quite similar results for Austria as well as for Romania. So the percentages do not vary very much, and you have to also consider that there are different numbers in both countries are in there. Then we had also the question, with which states will you coordinate within the IIS regulation? For Austria on the left side and Romania on the right side, the order is a little bit different, but the most important thing are the 3 summaries below. There's in Romania quite much more cooperation with EU member states than in Austria, so 77% to 63% actually. In Austria, we had even 6% which think that they neither cooperate with EU member states nor with third countries, which was quite surprising. So they're really living somewhere in the mountains, I think. But I don't know what the reasons are for this answer are, but maybe very subnational level authority respondents. And about 31% in Austria actually responded that they didn't know, that they don't know whether with whom they cooperate in the frame of this regulation, if they cooperate with EU member states or with third countries, or with none of them, or with both of them. So 31% really responded none of them. And Romania, it was a little bit less, 23% was also quite high as result. So this was just to show you the connection between the questionnaire and the related interview question. So we had this question also in the interviews, but we tried in the interviews to look also more for the reasons on the how. Yeah, how would you cooperate, and how would this concretely work then? Yeah, so we tried also in the interviews to go a little bit deeper. In the questionnaires, we got some quantitative results. In the interviews, we tried to get some qualitative results also, and some more explanations why something works and why not. Just some results on the transnational cooperation and coordination. That was an answer by the respondee AF. A means it's an Austrian, and F means, I think it was the 6th respondents from Austria. And so that respondent said cooperation is used to exchange information about the distribution channels and so with Germany. So that's more voluntary, that's more informal. And he was there also complaining that the Germans have a much better situation than the Austrians, because in Austria there is no federal conservation law, no federal framework above this all, while in Germany they have this federal conservation law, which combines all the federal states also, or what not combines, but which brings them much stronger into coordination and cooperation. But he also explains that in Brussels, there's this coordination from Brussels plays a key role among the rules for this whole implementation. But of course, coordination without cooperation is not enough. They have to work mutually, and the knowledge of this competence structure of nations and their interests, so mostly economically, and also the interests of all the involved parties are crucial for possible healthy working cooperation and coordination. That's something from the national cooperation and coordination. And that's a quotation from an Austrian respondent and below from a Romanian respondent. In principle, the typical major problems appear because of the federal provinces and the federal state powers. Oftentimes, federal provinces are misinformed, but we fight all together for improvement. So obviously, he comes from a federal province, he or she. And the Romanian response, on the interministerial level of our agencies, as the Romanian Water Agency, the communication is not very effective. So that's central steered. It's a central steered country. So you have quite some issues of national coordination and cooperation and weaknesses caused by the influence of the national competence distribution in a very federal organized country, as well as in a very central organized country. And both competence distribution systems here influence the respective national and transnational coordination cooperation regarding this regulation. Conclusions and recommendations. The current situation of cooperation and coordination in Austria as well as in Romania make it difficult actually for the European Commission to receive a realistic image in a EU member state, in those EU member states, of the situation of IES and the implementation. And it makes it also difficult for the Commission, for the European Commission, to be able to offer helpful support if the national cooperation is so poor like in Austria and Romania. Recommendations, more studies on openness and awareness of nations and stakeholders, improve the approach for a more needed sustainable future, and strengthen coordination and supranational, national and subnational levels. And that's perhaps the hardest, to convince the stakeholders and governments to comply through coordination and coordination. This is the paper I mentioned. It's recently published. It's actually open access. Everybody can download it. And there's another paper just in progress, which the original abstract was actually based upon, but we're working on this still. Yeah, that's it. Any questions? That's not an invasive species. That's not an invasive species. So thank you very much.
Great. Thanks so much, Volker, for a wonderful talk. And it's very important that it's open access to allow people to actually gain the benefit of your research. I think it's also, I also appreciate in terms of taking a survey that you're not just coming up with the quantitative data, but qualitative data as well in terms of how will the cooperation actually take place. So if folks do have questions, if you could please type them into the question box. We're going to hold them until after we hear from our next speaker, but feel free to type them in while they're fresh in your mind, or you can just ask to have your mic unmuted as well. We're happy to do that.
Thanks, Richard. Thanks, Richard, for the 27.
Yeah. And Volker, we very much appreciate your staying up so late into the evening.
I will not work another 3 hours today, so fine.
Good. Okay, so it's early for you. Excellent. So it's my pleasure to introduce Emily Prue. She is a Stetson University College of Law student. She is a third year, will be graduating in May. She is the president of Stetson Law Democrats. She is the Go Green Committee Chair for the Student Bar Association, and like Kate, is also a student editor on the Journal of International Wildlife Law and Policy. And I also have to note that she is the flute player, the flautist for our band, the Officious Intermeddlers, which is the unofficial Stetson Law House band. But she's not going to be talking about music here. She's rather going to be talking about dealing with apex predators. Emily, I'll turn it over to you now.
I should have known you were going to throw that in there. Can you guys hear and see me?
Yes, it's all well, let's see. Actually, we can hear you. We can't see you.
Okay, let me see if I can fix that. How about now?
There we go. Okay. Perfect.
Great. So I just wanted to start out saying thank you guys so much for participating and sharing your research and listening to mine. I hope wherever everybody is in the world, everybody's safe and happy and healthy. So I'm going to spend the next couple of minutes talking about the collaborative efforts between global authorities and indigenous and rural peoples to better manage the relationships between rural and indigenous people and snow leopards. But one of the really interesting things about this topic is it's kind of broad-reaching in a sense, because a lot of these issues are actually all these issues are not exclusive to the snow leopard itself. It's just an interesting case study. So the Snow Leopard Trust actually recently just published an article entitled "In Conservation, People Are Partners, Not Perpetrators," and it discussed some of the ways that even with all of our best intentions, we can accidentally end up alienating certain groups of people when it comes to doing environmental justice. And in order to create this kind of the kind of long-lasting and effective environmental change that we all want to see, it's going to be much more prudent to adopt this kind of no man left behind approach. And one of the ways that they point out that we can do this is by asking just, what do you need? By seeking to help our fellow man in such a way that allows the group that we are actually seeking to assist to kind of guide us in the way that's going to best help them. We allow for not only a more positive impact, but a better rounded one as well. For example, sorry about that pop-up. For example, myself, growing up in Naples, Florida, I have not had a lot of personal run-ins with snow leopards, which might be hard to believe, but it's easy then for me to make some kind of blanket assertion like, no one should be killing these animals. But I've never experienced the economic loss of a snow leopard coming in and destroying all of my livestock that I was going to use to feed my family. But for people in the world who have experienced that, the solution appears very simple, which would be to kill the leopard. And the questions that we should be asking is not how could anyone kill these animals, but rather what assistance can we offer to make sure that this stops happening. Just a couple of quick, a quick rundown about the snow leopard itself. It's known as one of the world's rarest predators, and for good reason. Not only are their numbers low and getting lower, they're very hard to access. Not a lot of us spend a lot of our time in the Himalayas, but researchers estimate that the snow leopard population has decreased by 20% in the last 2 decades. Leaving us with what is estimated to be somewhere between 4,080 and 6,590 snow leopards left in the wild. And the way the math for that kind of works out is that we lose on average, since the year 2008, we've lost on average between 221 and 450 snow leopards every single year from poaching and retaliation kills from herders and farmers. Like many other species, the greatest threat to the snow leopard's continued existence is human beings. But unlike most other species, what's really interesting about this is habitat loss doesn't seem to be a huge contributing factor. Altered habitats with the global climate crisis and whatnot are definitely playing into this, but the adversarial nature between man and snow leopards is often with direct contact, which is kind of unique, especially, when you're looking at apex predators versus other classifications of species. So just as difficult as it is for snow leopards to live with people, it is for people to live with these animals. And most notable of a threat is the tendency, of course, of snow leopards to make off, and apex predators in general, quite frankly, but to make off with livestock. And this is a huge economic imposition on the people who are directly affected, as well as local and national governments in general. And something that, speaking of local and national governments, one of the things that they have tried to implement is this kind of compensation program, and I'll get more into that in a couple minutes, but that tends to work a lot better in areas that are more economically stable. But barring that, they can be kind of, the compensation programs themselves can be kind of disadvantageous because they don't necessarily take into account the entire economic value of whatever it is that was lost. And so international treaties as a whole have obviously done tremendous work to mitigate the exploitation of animals on a broad scale. But as we all know, these acts of legislation tend to be very broad and sweeping. And while effective, typically in the areas that they are seeking to be effective in, because they're so broad, they can leave a lot of cracks that need to be filled in. And obviously, partially to blame for this is the scope of the treaties themselves. CITES doesn't contain provisions regarding the needs of indigenous and rural communities because that's not what the treaty is seeking to address. And while there could be an argument that maybe a new treaty would be a proper solution, that's often a very long process, and I personally think it's unfeasible to assume that international legislation is going to be able to stitch up every single tear in the fabric of our biodiversity, and that's kind of where we come in. The IPBES Global Assessment estimated that there are 1 million plant and animal species that are sitting on the brink of extinction, and so this is, of course, not an issue, like I said, that's specific to snow leopards, but the work that's being done to mitigate the destruction of the snow leopards on even a smaller and sometimes more localized scale can offer insight into some more creative and effective solutions that can be implemented on a grander scale. So what do we do? One such possible solution was actually put to test by the Snow Leopard Trust itself in a remote village in India. And the group was called out after a herder slaughtered a snow leopard after the leopard broke into his corral and killed over 20 sheep and goats. And killing the leopard, of course, was against the law, but rather than seeking to punish the herder, the Snow Leopard Trust sent researchers out and they asked him, what do you need? Like, how did this happen? What can we do to fix this? And they found out that the solution was actually a lot easier than they thought. He needed, the leopard had broken in through an open window. And so what they did is they installed some reinforced metal bars over the window to the corral. And they started doing this in neighboring villages and in neighboring corrals. And I think it turned out to be less than $100 per household that they needed to reinforce all of these corrals. And it cut down their percentage of successful snow leopard attacks by a tremendous amount. And so it just kind of goes to show that even something as simple as going in and reinforcing infrastructure that already exists can help kind of mitigate this struggle. They've had instances, the Snow Leopard Trust has had instances of having to go out and just even install a new fence or just take some of those minor steps that aren't necessarily completely cost prohibitive to help kind of mitigate this problem. And so to revisit what I talked about a couple minutes ago, the compensation and insurance programs have yielded awesome results when they're implemented properly. Scientists at the Nature Conservation Foundation in India have been encouraging herders and farmers who are financially able to purchase kind of cattle insurance from the government. And basically what happens is if you are, let's say, a cow herder or something, and a snow leopard comes in and takes out some of your livestock, then the government will reimburse you the value of whatever animal was lost. And so this helps cut down on the retaliation killings, because the argument then is you're not losing as much as you would have if you hadn't gotten repaid for whatever it was that you lost. This is, like I said, this has been particularly successful in areas of greater economic security. And then lastly, this is one of my favorites. This is probably one of the most creative things I've ever seen. And this idea actually originated in Botswana in Africa, and it was to combat the number of lion attacks on cattle, but it's being implemented throughout the rest of the world. Because ambush predators, which is most apex predators, particularly big cats, rely on their ability to not be seen. And so what farmers and herders across the world have taken to doing is creating almost this, it's like a brand of sorts. And they put the brand on the backs and sides of their cows. So it looks, as you see in the picture, it looks like eyes. And so these predators are thinking that they're being seen, and it's cutting down on their attacks as well. And it's just another example of how you don't necessarily have to, you know, break the bank, so to speak, to come up with these creative solutions, and how it doesn't always fall back on, you know, enacting this broad-reaching legislation. It really does come down to the creativity of local communities and the ability of some of these conservation groups to step in and offer a creative solution and foster what is already there. And you know, cultural and biological diversity are inherently linked to one another, and as such, the preservation of both of those has to go hand in hand. The ideas are out there, and the implementation is often a lot easier than we'd like to give it credit for. Something as simple as painting eyes on the rear end of a cow can make all the difference in the world to the world's herders, who are often the economic bedrock of their communities. Like so many other things, the best way to fix the problem is by working together and listening to one another and asking just that simple question: what can you need? How can we help you? And quite frankly, the time has never been better, or more pressing for that matter, to come up with creative and effective solutions to take it upon ourselves to close some of these gaps in international legislation. So thank you guys so much for listening. Let me know if you have any questions or anything, but this has been great.
Great, thanks so much, Emily. And I very much appreciated that you noted sometimes a disconnect between how people often in the West may view the risks associated with human-wildlife interaction, where we may be outraged with retaliation killing of a snow leopard, yet at the same time, as Ari noted in his talk, we can't even have a civil debate about domestic cats, and we don't even want to inconvenience ourselves with that, and that doesn't even involve a livelihood. So thank you for that, and let me open up for questions now. Yep, thanks. Yeah, Volker, if you could join us, and as well, thank you. And so if anybody has any questions, if you'd like to type it into the box. And let's see. So we have one from Richard Cadell for Volker. He says, really, you want to unmute yourself and speak, Richard, or you want me to read it for you?
I can read it, actually. I see it. If you want to add something to the question, Richard.
Oh, sorry. Yes, sure. I was gonna.
Oh no, here we go. Here we go.
I'm back. Hey. Yes. So Volker, really interesting empirical work, and really looking forward to reading your paper on that. So I was wondering whether you felt that that this kind of reveals that the invasive alien species regulation is far too bureaucratic a regime to be entirely effective, which is one way of looking at it, I suppose, a bit cynical. And a question for Emily, which I loved your presentation as well. It was really interesting. And the thing that I kind of wondered was, do we spend too much time in international wildlife law thinking about all these grandiose projects and not enough time doing the real community-based solutions that you showed to great effect there? And I was also wondering whether the Convention on Migratory Species had contributed anything useful with snow leopard conservation at all on the ground there.
To answer your first question, I absolutely think that sometimes we spend so much time trying to come up with this almost like one-size-fits-all solution, and that's oftentimes not necessarily the most prudent or most effective way to do that. I think, you know, there have been a lot of, I guess theoretically more simple kind of boots on the grounds efforts to to help bring back some of these species that don't necessarily have to have everybody in the entire world in it all at once, because it is a lot of times those local communities that are interacting directly with the animal itself. As far as your question about the, was it the migratory species? I'm sorry, could you just repeat the second question?
It was on CMS, the Convention on Migratory Species. I don't believe that they address the snow leopards directly. I'm not entirely sure. I could get back to you on that, but to my knowledge, no, there wasn't any direct reference to that.
Cool. Thanks very much.
Thank you.
Okay. Yeah, your question. I wonder if it's a neutral question or if you have a certain expectation in your answer to the answer. However, it's a regulation.
Okay.
I understood it, of course. It's a regulation, therefore you don't have much work for the transformation because it's there. And then you have just as an authority think what else additionally do the requirements of the regulation you do. If the requirements of the regulation are already enough or far too much, then you perhaps do not do those national or regional lists. Whether it's a big burden for the national level depends also a little bit how the national level understands the regulation. In Austria, for example, they put the work to the nature conservation authorities, but many other authorities, and I did a study actually on the competence distribution in Austria and on the implementation on the potential implementation of the regulation. I found about, I think, 20 authorities and about 20 sectors of responsibilities which are involved in the implementation. And you can imagine what happened with my study. It disappeared in the desk because nobody wanted to have that work. So on the one hand, yes, on the other hand, no. The regulation, I think, is quite straightforward and gives clear indications what to do. On the other hand, authorities tend not to get additional work, I would say, additional to the work which they already have. And that's why my study went into a desktop and was not any more seen since then, because it would have put work on quite 15 different authorities with 10 to 15 different legal sectors to do some more work, yeah? Like streets controls, like shipping controls, yeah? These sectors currently still feel they are not responsible for implementing this regulation. And that's quite a strange view on the regulation. So on the one hand, yes, the authority is quite straightforward. So there is not much bureaucratic burden, except what of course is prescribed by the regulation. On the other hand, no, because authorities try to look away, do not look at the work, do not look at their responsibilities, and do not want to take over the responsibility. Differentiated answer, but that's from my national experience. I'm not sure how it's done in UK, for example.
No, that's great. I think it's a similar situation where you start drilling down into who's responsible for all of these myriad issues, and then you really sort of see the difficulties in implementing it on the ground. But yeah, thanks. That's really helpful insight. Thank you.
And if I could just follow up on the point that Richard had made earlier, I think in terms of guidance versus community-based solutions, and at least share with the group the struggles that we had within the Ramsar community at the STRP, the Scientific and Technical Review Panel level. The goal of the STRP is to provide scientific advice and guidance to the parties, but it's very, very difficult and challenging to do that for invasive alien species, because at most we could provide general guidance, and then the usefulness of that I think is very limited. I mean, what is really needed is more specific guidance to deal with particular invasives, and really more working with folks on the ground and community-based solutions. So at least that was my limited experience at the Ramsar level.
Of course, I think also the local implementation is key, and usually conservation authorities have not much stuff. Yeah. So if there is something like this comes down, yeah, they get nervous. Yeah. Who has to do it? Yeah. And in Austrian case, it was put everything on the provincial authorities, and in Romania, it was also finally put on the provincial authorities in the implementation. In Austria was legislation and implementation put mainly on the provincial authorities. So in Austria, perhaps the provincial authorities are even double covered with work. So.
All right. Let's see if there are, don't think I see other questions at this point. If people do have further questions, please just send them to us, and we can send them on to our presenters. So thank you very much, Volker and Emily, and really appreciated your presentations and your responsive answers to the questions, and now we will turn to our next session, a special presentation. So Damon, if you could please share the screen with Dr. Chin. All right, excellent. So it's my real pleasure to introduce Dr. Tianpo Chin. He is professor of law and vice dean at Wuhan University. He is also the director of the Research Institute of Environmental Law at Wuhan University, the editor-in-chief of the Chinese Journal of Environmental Law, the Secretary General of the Chinese Society of Environmental Law, member of the IUCN Commission of Environmental Law and the IUCN Commission of Ecosystem Management, as well as being a member of the governing board of the IUCN Academy of Environmental Law. We're truly honored to have you with us, especially given the circumstances and the issues that the world is facing. And we very much look forward to your presentation on China's wildlife law in the context of public health.
Awesome, great. Hi, good morning, everybody. Yeah, I'm Tianpo Chin from the Wuhan University, China. Currently, I'm a visiting scholar at the Duke University in the United States. Perhaps many of you have no idea where is Wuhan or Wuhan University 2 or 3 months ago. But now I believe almost everybody knows the location and the pronunciation of the city, which is actually very beautiful and modern. It's my privilege to be a special presenter today. Many thanks to Professor Gardner, Professor Okuno, Professor Will Bruce, and all the co-organizers for bringing me to the wonderful conference. I'm glad to meet virtually all of the participants. Actually, someone I've met before, like Volker and other presenters. The topic I want to share today with all of you is China's wildlife in the context of public health problems and proposal. It is easily to understand why I choose this topic. So after the outbreak of the COVID-19 situation, there were a lot of discussions on the potential relationship between the wildlife protection and the public health in China. So many general public concerns, the huge public health risks associated with the use of the wildlife. So today I will give you a very brief introduction to China's wildlife protection law and its relationship with public health. So as maybe you have known that China is one of the mega biodiversity countries in the world, and China is very rich in wild animals. It ranks third in the world in numbers. The eighth in birds, seventh in reptiles, and on seventh in amphibians. So many species of animals in China are endemic to China. So including the very famous, you know, as giant panda, the Tibetan, the Tibetan tapir, the bear, the South Chinese tiger, and of course the golden monkey. I was lucky to take a picture last year with it. So the use of wildlife is a common practice of the world. According to the WWF, the local people have a long history in using the wildlife, and they have a very deep understanding of the wildlife, and wildlife are still working. Like many other countries, China have a more than 2,000 years history of sustainable use of wildlife, including use them as food or as other purpose. So here are some examples showing how the wildlife are used, for example, as meat in different countries. So this is deer meat in North America. This is bear meat in Finland, and this is kangaroo meat in Australia. So China started its legal protection of wildlife in the 1980s, almost immediately after its joining the CITES Convention. The original purpose of the 1988 wild protection law, which is based on the China's long history and culture, the purpose is to try to balance the protection of wildlife and the utilization of wildlife resources. But after two slight amendments in 2004 and 2009, and a major revision in 2016, one of the fundamentals of the law has been shifted from the rational utilization of wildlife to regulated utilization of wildlife. And the purpose is to follow the requirements of sustainable development, try to achieve a kind of a balance among the food, biodiversity, and the environment. For the purpose of the implementing of the wildlife protection law, China enacted a lot of governmental regulations, ministerial decrees, and other legal rules. So here are some examples. There are several key provisions in the wildlife protection law. For example, the law stipulates the state owner of wildlife resources, and the law requires the forestry and fishery departments under the state council to be in charge of the protection of terrestrial and aquatic wildlife respectively. And China protects the four major categories of wildlife differentiated by levels. So namely, two national protected wildlife, first grade and second grade. You can see from this picture, the brown one. And the two local protected wildlife. What animals and the wildlife with important and ecological and scientific social values. So in short, we call it wildlife with three values. The law does not encourage domestication and breeding of wildlife for various purposes anymore. But a program carried out by scientific research institution for preservation purpose and captive breeding of wildlife for some commercial purposes, such as medicine, are still allowed. So as long as license is obtained from provincial authorities, with preconditions that the captive breeding of wildlife should be beneficial to the protection of the species and its scientific research, and no destructive of the species in the wild situation. The law in general prohibits the trade of national protected wildlife with exemptions for scientific research, captive breeding, and public exhibition or performance. So in these cases, approval must be obtained from the provincial authority, and a special label must be obtained and used to ensure the checking. So you can see in the down area of the slide, this is kind of a label used for the wildlife and its products. The law also protects the wildlife habitats in many different ways, such as the establishment of nature reserve, building of corridors, or other ways. In addition, the law also prohibits majority of the hunting methods. So from this picture, you can see a lot of hunting methods are banned according to this law. Another very important development of the law, when it was revised in 2016, is that it began to prohibit the use of the limited wildlife as food. So, namely, two types of the national protected wildlife are generally not allowed to be eaten. And for this local protected wildlife and the terrestrial wildlife with three values, it must be some proof of this lawful origins. Otherwise, it cannot be eaten. So, in addition, the illegal poaching of wildlife for food is also prohibited. The law has noticed the epidemic sources and wildlife diseases, and required the departments for the protection of wildlife and veterinary medicine to monitor and forecast epidemic sources and wildlife diseases, and make an emergency response plan for wildlife disease epidemics, and to take effort to prevent and manage the zoonotic diseases. So obviously, we can say that the law has achieved several positive effectiveness. So, for example, like the Asian elephants, the giant panda, and several other endangered species have been very well rescued, protected, and restored. The wildlife breeding and utilization activities have been strictly regulated and controlled. And various types of nature reserves for wildlife have been established at the national level and provincial level and even local level. However, once the outbreak of the COVID-19 in Wuhan 3 months ago, the majority of the general public, as I mentioned just now, that they believe that the COVID-19 is very likely to be originated from the use of wildlife. They actually have already some scientific findings about the human infectious diseases caused by wildlife. So here are some figures. 70% of the existing human infected diseases are zoonotic, and several other figures to show the relationship between human health and the wildlife. However, according to the statement of CDC of the United States, right now we do not know the exact source of this virus. We still need to more scientific evidence for that purpose. So, in such circumstance, if we took a perspective of precautionary principle, we can find that there are some major deficiency of the existing wildlife protection law in China. So I will go through them one by one. So firstly, the deficiency is that there's no substantial consideration of the public health in the wildlife protection law. So from this picture, I show you in the bottom of this this slide, you can find the animal health and the human health. Actually, they are interrelated. But the purpose of the wildlife protection law are very limited to the wildlife itself, namely to protect wildlife, to rescue rare and endangered wildlife, and to preserve the biodiversity and ecological balance. But obviously, it did not consider the interrelationship between the wildlife protection and the public health protection. So if we consider the situation that China has already witnessed the SARS disaster in 2003, and the biosecurity concept has been very familiar to the general public, and has been accepted by the general public and the leadership. So it is really a big shortcoming for the law. Does not consider the public health very well. So as a result of the first deficiency, the law does not have very effective coordination with other relevant laws. So of course, the wildlife protection law is not the main force to combat the infectious diseases, but it has a lot of relationship with this diseases. For example, the animal epidemic prevention law, it includes the illegal hunting of wildlife from the animal quarantine system. This, in turn, promoted the illegal hunting of wildlife. And the entry and exit animal and plants quarantine law is mainly prevent the introduction of animal infections from other countries, but not so much regulations are laid on the epidemics caused by domestic wildlife. And the law on the prevention of control of the infectious diseases provides more regulation on existing zoonotic diseases. Few on the new types of infectious diseases like the COVID-19, especially those diseases that affect only people but not affect wildlife are not regulated by this law. This is very interesting. So the third aspect is that no clear definition of wildlife has led to important legal questions. Number one, whether animals domesticated, so after capture from the wild, should still be legally regarded as wildlife. Or secondly, is whether the domesticated animals should be regarded as wildlife after they are released into the wild environment. On the other hand, as I mentioned just now in the previous slide, China's wildlife protection law only protect 4 types of wildlife, not all wildlife. So for those maybe a lot of wildlife which carry the virus, actually they are not be covered and regulated by the law. So that is a big loophole for the public health. So the last deficiency is the still lawful utilization industry, which actually in some way increase the risk of public health. Considering that the wildlife domestication is a key part of rural development, eco-tourism, and poverty alleviation in China is very important strategy. And it's valued about 75 billion by 2017 report. So the wild protection law, when it was revised in 2016, it keeps the wildlife breeding industry. So, but the situation is that the law emphasizes the issuance of a permit, but after the operator gets this permit, there's not so many regulations to oversight the following management and the supervision of the captive animals. And actually, each step of the industry chain, such as hunting, breeding, transportation, consumption, will inevitably increase the risk of epidemic sources and wildlife diseases. Facing such a challenge by the viral outbreak, China's competent authority took timely legal responses. So on January 26, three competent authorities, the State Administration of Market Regulation, the Ministry of Agriculture and Rural Affairs, and the State Forestry and Grassland Administration, so temporarily banned the trade of all kinds of forms of trade of wildlife. But more important, on February 24th, China's Parliament, the Standing Committee of the National Congress, adopted a very important, very timely decision to comprehensively prohibit the illegal trade of wildlife, to eliminate the bad habits of wildlife consumption, and to effectively protect the health and the safety of the people. So according to this decision, there's a blacklist requirement. That means the food consumption of terrestrial wildlife, almost all kinds of terrestrial wildlife, bred or raised in captivity, should be prohibited. And only a very small exception, that is in whitelist. So the animals already included in the list of livestock and poultry genetic resources are still edible. The decision also required to implement strictly the quarantine provisions of existing laws. So that's the second legal response. Thirdly, just several days after the decision, the State Forest and the Grassland Authority, that is China's main competent authority on wildlife, issued another rules for implementing the decision. The rules strictly crack down on the wildlife hunting, illegal trading, and other activities, and resolutely ban illegal wildlife markets. And the rules also comprehensively rectified the companies for artificial breeding, operation and utilization of wildlife, and the withdrawal and cancel all issued license and permits according to the laws. The third aspect is of the rules is that all obligations for hunting, operating, and other activities of animals for the purpose of eating, of course, should be halted. And the approval of non-edible use of wildlife, such as research, medicine, and exhibition, should be strictly regulated. So fortunately, these actions have taken by the Chinese government and the parliament reflects our progress. So namely, it reflects the precautionary principle, and it incorporates the public health consideration. The simple is that the decision, the public health has been accepted as one of the main purpose of the decision. So you can say it says to effectively prevent major public health risks, to effectively protect life and the health of the people. So to this end, the decision calls for following coordinated arrangement for the amendments of relevant laws. So on the other hand, there are still several problems to be solved in the following steps, especially when we amend or revise the laws. Number one, the decision itself is only a parliamentary instrument. It's like law, but it's not law actually. It's not as comprehensive and systematic as laws. It's only valid for temporal and transitional period. Secondly, the terrestrial and aquatic wildlife still need to be clearly defined by the new legal regulations. Thirdly, there are still some public health loopholes in the trade of living wildlife as pets, such as parrots, amphibians, and reptiles itself. So which are right now are not considered by the decision. So the year of 2020 will be a very important year, maybe another cornerstone year in the history of development of China's wildlife protection law. So since the decision by the parliament has indicated the direction of the revision of the wildlife law and other relevant laws, we can foresee the next steps in China in coming months or maybe next year. So firstly, the concept of public health will be emphasized in the process of amending relevant laws. So not only the wildlife protection law, but also the animal epidemic prevention law, the prevention and control and of infectious disease law. And meanwhile, the new comprehensive and umbrella biosecurity law is also on the drafting. The public health is one of the main purpose of this new law. And the breeding, the management, and the utilization of the wildlife for food purpose will be, of course, strict banned, and any violation will be strictly punished. And the whitelist system will be adopted for the commercial breedings, management, and utilization of wildlife for other non-edible purposes. And the quarantine regulations will be more strict and more detailed and more operational. So in addition to the domestic legal actions in China, so I'd like to introduce one more suggestion, namely to introduce the concept of the one world or one health, which was proposed by the WCS and several other international wildlife NGOs. So in the context of the globalization, the illegal trade, also illegal consumption in international or in transnational wildlife will of course accelerate the long-range transfer, the organization and crossing species and transmission of unknown pathogens. So it's obviously a public health challenge for the whole world, like the COVID-19 right now. So to deal with such challenges, it is necessary to strengthen the international corporations to jointly combat the global transnational wildlife trade, wildlife consumption, or wildlife transportation. So not only this cannot be done by any single country. So that's all my presentation this afternoon, and many thanks for your listening. I do hope the world will cooperate closely to combat the COVID-19 and to overcome the tough situation as early as possible. And when everything returns normal, I will be very pleased to host the visit of all of you in Wuhan. As maybe you have known that we have the best environmental law and biodiversity law program in China, and we have the most beautiful university campus in China. Thank you so much. And any questions, any comments?
Thank you, Dr. Chin, for that excellent presentation and for the kind invitation to visit as well. We very much appreciated your providing that background on China's wildlife laws and the efforts now to take public health into consideration and incorporating that. We have, let's see, we have looks like several questions coming in. Volker, did you want to unmute your mic and ask your question?
Yeah, sure. Adrian Barrow.
Hi.
Thank you for the presentation, and I can confirm that the campus in Wuhan is really wonderful. So, yeah, thank you for a really good overview and for analysis regarding the health issues. My question would be beyond the health issues. And do you see any bigger challenges still for the Chinese wildlife protection law, whether in the law itself or it's in its implementation, enforcement, a part of the health issues you mentioned already? Yeah? Do you see any things which should be still changed, perhaps in the law and the implementation of the law, a part of the health issues? Thank you.
Oh, okay. Yeah, that's a very good question. Thank you very much. Of course, the situation, the current situation from the legal perspective, there are many reasons. We can at least have the problems from as the law itself. The law are not perfect. Law has several shortcomings and deficiencies, as I mentioned. It has no idea, no regulation, no provisions on public health consideration. And several other problems with no clear definition. So what is wildlife in China? We don't know exactly. Not only for the professionals, but also not only for the general public, but also for professionals. Second is that the enforcement. Yes, we do have some problems. We have a very weak, sometimes the enforcement due to the several factors. So number one, we have not enough staff members at the local level. You know, the wildlife normally in the remote areas. In these areas, the local governments have very few human resources and financial resources. We do not have a sufficient, technology. For example, when we to enforce the law in the open market to check the meat, for example, for the meat, if the meat is wildlife, well, you cannot distinguish from the meat from the wildlife, the meat of wildlife and meat of bred animals. The third is the general ideas of the general public. So as I mentioned, China has a long history of using the wildlife for food, for medicine, or for other purposes. So recently, in recent years, I think the consumption of wildlife as food, I think, is better. Very few people in China like to eat meat of wildlife. Only a very small people I think some stupid people, they want to be different. But for medicine, for traditional Chinese medicine, maybe it's a bigger encouraging factors. So another encouraging factor is that as pets. For example, the turtles, the parrots, or even someone like the cats or dog or even snakes. So that's another encouraging factors to the general public. But all this, as I mentioned just now, all the steps in this process have some kind of risk in place the epidemic sources and the wildlife diseases. So
thank you.
If we want to, sorry, one more sentence. If we want to change this whole situation, so to have a better law is only one of them. We need all kinds of efforts together.
Thank you, and greetings to you in Tuk. Hope you feel fine.
Thank you.
Thanks, Volker. And actually, your question, what is wildlife, and defining wildlife harkens back to the opening presentation by Paul Boudreau in terms of the law defining species. We have a couple questions in the question box. This one is from Jan Prisner Levine. Will the COVID crisis lead to a change of policy regarding tiger farming in China? Could it lead to a phasing out? Thank you.
Yeah, generally, actually, the tiger. I'm not sure which type of tiger. So tiger is not generally is national protected wildlife. So this kind of animal, China's law is only allowed for artificial breeding for research purpose. It cannot be used for commercial purpose. So, but I'm not so sure if we have some tigers are not on the national protected list. That one on the program. But according to the decision, it is possible to have a more limited activities for futures wildlife for breedings, including tiger or the other species.
If I could go back to what Volker was asking about, just so I better understand, who's responsible for enforcement of wildlife laws in China? Is it who has primary responsibility? Is it at the local level, or is it the national or provincial?
Oh yeah. But firstly, the main competent authority is forestry department. So we have several departments are responsible for the wildlife. But when the wildlife entered into the market, it was under the control of the state market regulation, but generally by the forest department. But the daily enforcement are carried out by the local forest department. But the situation is that the China is on a very dramatic governmental reorganization. It seems that in the near future, the forestry department will be deleted or merged into other departments. But the function will be kept, of course, but the department will be not. And so that's the reason that at the local level, normally they have a very few. For example, a county, maybe only 20 or 30 people, but majority of them, they are tasked to plant the forest, to plant the trees. So protection of the wildlife is one of their tasks, not the only one. So that's the problem. So the lack of the human resources is a big problem, big challenge.
Thank you. Let's see, we have another question. This one is not related specifically to your talk. But the question is, what is China's current position with respect to the importation of elephant ivory?
Oh, this is a very important question. China has stopped the importation of these products, and it is a very controversial in several days ago. But now we have reached a consensus. We are not allowed. We do not allow the importation from outside anymore, and also we try to phase it out the existing operators and existing virus the products. So that's but it need a little bit of time. But this is the concept has been generally accepted. So we should not use or consume this product.
Thank you. Thank you very much. So it's a real pleasure to welcome Will Burns. As I noted earlier when we started off this morning, Will, that you are the originator of this conference. You started this conference back in the day, along with founding the Journal of International Wildlife Law and Policy. And Will is now a professor of research and is the founding co-executive director of the Institute for Carbon Removal Law and Policy at American University in Washington, D.C. Prior to that, he served in many different capacities, including as the founding co-executive director of the Forum for Climate Engineering Assessment, the director of the Energy Policy and Climate Program at Johns Hopkins University, and Assistant Secretary of State for Policy for the state of Wisconsin. He's also served as well as the president of the Association of Environmental Studies and Sciences and was the 2019 recipient of that organization's Lifetime Achievement Award for scholarship and service in the field. And he has also been, I have to note that he has also been a long-time final round judge for the Stetson International Environmental Moot Court Competition, and we should be giving you a Lifetime Achievement Award for that as well. But thanks for joining us, Will, and we look forward to your presentation on carbon dioxide removal and how this is going to affect biodiversity.
Great. Thank you so much for that, Roy. And thank you, everyone that's hung in for the end of the first day of the conference. I appreciate it, and I'll try to keep my remarks fairly brief for those of you that are in the Eastern time zone or beyond in this context. So the Paris Climate Agreement, which everybody knows, entered into force in 2016, establishes the salutary objective of keeping temperatures to, quote, well below 2 degrees Celsius, and at least aspirationally seeking to hold these temperatures to below 1.5 degrees Celsius. Unfortunately, the pledges that the parties to the treaty have made, the so-called nationally determined contributions, to date, put the parties well off of kilter in terms of meeting those objectives. Indeed, two recent analyses indicate that even full implementation of the NDCs that have been made by the parties to date would put them on track for temperature increases of somewhere between 3.2 and 3.7 degrees Celsius by the end of the century, with temperatures slated to continue to increase for centuries thereafter, given the inertia of the system. And what we know is that temperature increases that go beyond 2 degrees Celsius and get into the realm of 3 to 4 degrees Celsius can be catastrophic in terms of both human institutions as well as ecosystems. So, given the feckless response of the world community in reducing its emissions to date, there's been increasing recognition in the world community that there may need to be large-scale deployment of so-called carbon dioxide removal approaches, also called negative emissions technologies, and providing a working definition here, and then we'll drill down into some of the specific technologies that we're talking about later. But most generally, These are options that seek to remove carbon dioxide from the atmosphere and then sequester, meaning store that carbon either underground, such as in saline aquifers or abandoned coal mines, or in the world's oceans, or seek to utilize that carbon dioxide for things such as energy production or chemical production or materials production and other potential processes. Carbon dioxide removal is also generally recognized as one of the two broad categories of so-called climate geoengineering approaches, the other being solar radiation management. But here we will focus on this strand of carbon dioxide removal, both because it's my primary area of emphasis, as well as the fact that it is likely to be the technologies that are to be deployed, at least in the immediate future. So indeed, in the Intergovernmental Panel on Climate Change's fifth assessment report, 184 of the 208 integrated assessment models that were able to effectuate temperature scenarios below 2 degrees Celsius in a cost-efficient manner assumed substantial deployment of these so-called carbon dioxide removal or negative emissions technologies. And when I say assume, I mean at an extremely large scale. As you can see from this chart, many studies contemplate that the global community may need to sequester approximately. Yes.
Well, I'm sorry to interrupt. I'm not sure that the slides are moving.
Oh,
or has my screen frozen?
Oh, huh.
Yeah, no, I'm getting confirmation from Erin that she doesn't see a chart either.
Well, that's weird. Let's see, because I can see them advancing on my end. Let me go to.
Because we see your cover slide.
Right. Let's see. I can see people. It says people in the icon. It says people can see your screen.
Yeah, Damon, maybe we want to reboot that, take it away and restart it.
Let me try this.
Okay. Okay. All right. Let's see. Okay. Yeah. Right. Okay. All right.
Okay. Is that working now?
We've got it. Yep. We're on carbon dioxide removal options right now.
All right. My apologies. So again, the chart that I was discussing here, the world community is talking about potentially having to sequester somewhere between 13 to 20 gigatons or billion tons of carbon dioxide per year, and perhaps a cumulative amount of more than 1,000 gigatons by the year 2100, in addition to aggressive reductions of greenhouse gas emissions if we're to meet the Paris Agreement's objectives. Additionally, a number of studies have indicated that carbon dioxide removal could play a critical role in so-called overshoot scenarios, in which temperatures rise to above 2 degrees Celsius, and we seek to remove carbon dioxide from the atmosphere to draw temperatures back below 2 degrees Celsius, with the hope that we can also reverse any of the potential negative implications of rising above 2 degrees Celsius. Now, what are some of the specific carbon dioxide removal options that we're talking about currently? And I'm going to highlight a number of them that are in probably the most advanced stages of development, and then ultimately talk about potential impacts. So the one that has probably been discussed the most recently is large-scale afforestation. There's been a number of studies recently that have talked about potentially seeking to grow forests on as much as an additional 900 million hectares of land. And those studies have indicated that it could sequester extremely large amounts of carbon dioxide. Some studies talk about as much as 9 to 10 gigatons of CO2 being removed from the atmosphere annually by utilizing this approach, though others indicate that it might be a much lower number, perhaps 1 gigaton or perhaps even less. Proponents of this approach also tout the fact that it is the cheapest carbon dioxide removal option at an estimated $20 to $100 per ton of carbon that would be sequestered. The second approach that is often discussed and was discussed extensively in the Intergovernmental Panel on Climate Change's fifth assessment report and is slated to be discussed extensively again in the upcoming sixth assessment report is bioenergy with carbon capture and storage, or BECCS. The idea here is to produce energy with bioenergy feedstocks, whether that be trees or dedicated energy crops such as switchgrass or industrial waste or forest residues. That bioenergy feedstock could be utilized for production of heat, for example, or production of electricity, or for use in liquid fuels. After that bioenergy is combusted, of course, the CO2 would be released, but the facilities would be equipped with carbon capture and sequestration capabilities that would allow us to capture the carbon dioxide from the flue gas, subject it to pressure, turn it into a liquid form, and then ship it utilizing pipelines or rail lines or trucks for long-term storage. This technology is denominated a negative emissions technology because there is sequestration of carbon dioxide that occurs when one grows the bioenergy, and then that carbon dioxide is captured again in the CCS process, and more CO2 is captured by regrowing the bioenergy feedstocks that have been harvested. The third approach that's being discussed is direct air capture. The idea here is to have ambient air introduced to surfaces that would filter out the CO2, separate it using things such as calcium hydroxide or lye, and then again subject that carbon dioxide to pressure, turn it into a liquid form, and store it, or of course utilize it. The fourth approach that has been discussed in recent years is ocean iron fertilization. The idea here is that there are areas of the ocean that are deficient of a critical micronutrient for optimum production of phytoplankton, that being iron. And so the idea is to seed those areas with iron to try to stimulate the production of phytoplankton. Phytoplankton take up CO2 in photosynthetic processes. Indeed, 50% of all the photosynthesis that occurs on Earth occurs in terms of phytoplankton. And the idea would be that when these phytoplankton die, they would take a small percentage of the CO2 that had been sequestered with them to the bottom of the ocean, where it could be sequestered for centuries, allowing us to buy time as we seek to aggressively decarbonize the world's economies. And then finally, the last option that I would highlight here is something called artificial ocean alkalinization. The idea here is to increase ocean alkalinity by adding materials such as powdered olivine, which is a highly reactive mineral, or reactive lime, or calcium hydroxide, and apply this to ocean surfaces. This in turn would increase the alkalinity of these ocean surfaces, which would result in increased pH, which in turn would result in elevated levels of carbonate ions, which in turn would result in a decline in the concentration of aqueous carbon dioxide. This would enhance the disequilibrium between atmospheric and ocean-based carbon dioxide. And as a consequence, it would increase oceanic uptake of carbon dioxide and thus decrease atmospheric concentrations of CO2. Now, while many of these CDR approaches have been touted as ways to help us to combat climate change, Many of these options, especially at large-scale deployment, could also pose substantial risks, and researchers have outlined a number of those in recent years. For example, bioenergy with carbon capture and storage at large-scale deployment could require diversion of as much as 20 to 25% of the world's agricultural lands for use for dedicated energy crops. This could potentially raise food prices for some of the world's most vulnerable peoples by as much as 30 to 40% and require tremendous amounts of water. Large-scale afforestation might result in mass expulsions of those who rely on forest products for their subsistence. Artificial ocean alkalization could require the production of large amounts of minerals, which would have negative environmental impacts in terms of mining, as well as potentially releasing large amounts of chemicals or mineral dust into the atmosphere. However, to date, the research community in doing these assessments has almost entirely focused on these risks in the context of human beings. This presentation seeks to instead focus on the potential risks posed to non-human species, as well as to suggest how we might scrutinize and govern these threats to biodiversity and species under pertinent principles of international law. And that's what I'll proceed to at this point, is first of all, talk about some of the potential risks that carbon dioxide removal, negative emissions technologies might pose to biodiversity and wildlife. And I'll just highlight a couple of these briefly. First of all, in the context of afforestation and reforestation, massive afforestation programs could pose substantial risks to biodiversity. As much as 50% of the assumed carbon sequestration in some of the recent studies that comes from planting trees would occur in savannas and grassland areas. However, a number of studies in recent years have indicated that that protection of biodiversity in these ecosystems often requires the exact opposite approach. That is tree cutting as well as prescribed fires. Thus, massive afforestation in savanna and grassland areas could substantially undermine biodiversity in these areas, as well as the provision of ecosystem services in many regions of the world. In terms of bioenergy with carbon capture and sequestration, large-scale deployment of BECCS, even at relatively low levels of potentially sequestering 3 gigatons of CO2 a year, could require appropriation as much of 7 to 25% of the net primary production on Earth. This could, in turn, result in a conversion of large swaths of forests and grasslands into dedicated energy crops, and this could devastate ecosystems in many regions of the world. One recent study concluded that this could manifest itself in biodiversity impacts that would be equivalent to raising temperatures by 2.8 degrees Celsius. In other words, getting very close to what we'd see in terms of business as usual scenarios in terms of climate change. In terms of ocean iron fertilization, marine systems are extremely complex, and ocean iron fertilization might give rise to a plethora of different phytoplankton species, some of which might be undesirable in the food web, or even potentially toxic. For example, in one ocean iron fertilization field research study, the abundance and biomass of one phytoplankton species, Phyoscystis antarctica, was massively increased. This species proved unpalatable to mesozooplankton species in the area, which means that if this were to be done at a basin-wide scale, it could potentially imperil the trophic food web in that region, and potentially irreversibly. Ocean iron fertilization could also privilege fast-growing species of phytoplankton, including Pseudonychia, a phytoplankton species which produces domoic acid, a neurotoxin that can kill mammals and seabirds. Moreover, ocean iron fertilization could result in widespread eutrophication, proliferation of algae that could choke off light to species, and create toxic algae blooms that could kill species. One potent example of the impacts of eutrophication in recent years was in the Mediterranean, where toxic algae blooms result in the massive kill-off of dolphins in so-called red tides. And then finally, artificial ocean alkalization. Artificial ocean alkalization deployed at large scales could raise ocean pH levels in some regions above those that were experienced in pre-industrial times. And this could have uncertain impact on marine biota. One laboratory study concluded that alkalinity addition could, for example, disrupt the acid-base balance of marine organisms, including crabs and lobsters in that study. Additionally, the addition of alkaline substances could also result in the introduction of heavy metals, many of which are toxic, into ocean ecosystems, including cadmium, nickel, and chromium, with potentially adverse impacts in terms of toxicity, as well as potential transformation of ocean biogeochemical cycles and the provision of marine ecosystem services. So the question that arises then is, how might we scrutinize the potential benefits and at the same time look at the potential risks of these approaches at the international level, and what have we done to date? One thing that I would emphasize at the outset is that much of the regulation of carbon dioxide removal options would likely take place at the national level. However, there will be, and there should be, an international component, and that's what I want to focus on here. So I'd note that to date, 2 international regimes have already sought to assert jurisdiction over some aspects of carbon dioxide removal options. This arose out of a number of field experiments on one of these CDR approaches, which was ocean iron fertilization, primarily in the last decade. And as a consequence of a flurry of these field research experiments, 2 regimes sought to assert some regulatory purview. The first of these is the London Dumping Convention, established in the 1970s as a consequence of concerns about the placement of materials in the oceans that could have adverse impacts in terms of human health as well as in terms of species. In the year 2008, the London Dumping Convention passed a resolution on the regulation of ocean iron fertilization. And it essentially provides 3 components. First of all, it limits that research to so-called small-scale activities. Second of all, it limits it to so-called legitimate scientific research, meaning that one could not engage in such experiments with the idea of ultimately developing a commercial component, such as selling carbon credits in terms of any sequestration that might occur. And then finally, it provides that, as you can see here in paragraph 4, that there should be a case-by-case assessment utilizing a risk assessment framework that was developed under the London Convention. And indeed, in 2010, the parties did establish a risk assessment framework for any experiment that would occur in this context. Now, I would argue that the London Dumping Convention has a limited capability, however, in protecting biodiversity interests in the context of carbon dioxide removal deployment. And this is true for a number of reasons. First of all, the resolutions that are passed under the convention are not legally binding upon the parties. They are often persuasive, but not always adhered to, and might not be in this context. Second of all, this convention's resolution was limited to ocean iron fertilization only, and even if the parties were to expand the purview of regulation beyond ocean iron fertilization, it could only be extended to those activities that involve the placement of materials in the world's oceans. So it could apply, for example, to artificial ocean alkalization that we talked about before, but it would not be pertinent to many of the other carbon dioxide removal approaches that we've already discussed, such as bioenergy with carbon capture and storage, or afforestation and reforestation efforts. The London Protocol, which is contemplated to be the successor agreement to the London Convention, also became involved in the context of so-called geoengineering activities. And they passed a resolution, the parties to the London Protocol passed a resolution in 2013 that amends the protocol to regulate marine geoengineering approaches. Now, what this means, of course, is that if this amendment comes into force, it would provide for legally binding regulation in terms of the parties. So that would be a substantial step forward. However, it should be emphasized that the amendment will only come into force when 33 parties have accepted it, and to date, only 5 have. So we're left really with non-binding resolutions at this point. Moreover, at least for now, the purview of the regulations here are limited to ocean iron fertilization again, though it's contemplated that other marine-based geoengineering approaches could be regulated in the future. And then, of course, the last problematic aspect is the same with the London Convention. Again, this can only regulate carbon dioxide removal approaches that are based in the world's oceans and involve placing materials into the world's oceans. Now, the other regime that has sought to address carbon dioxide removal approaches is the Convention on Biological Diversity. And again, it responded to ocean iron fertilization activities. And it passed a resolution in 2010, as you can see here. Now, as you can see, one of the things that's striking here is it did not expressly limit itself to ocean iron fertilization, but rather more capaciously talks about any quote unquote climate related geoengineering activities that may affect biodiversity. And what it provided for was essentially the same criteria that were outlined under the 2008 resolution of the London Convention. It requires that there only be small-scale scientific research, at least for now, until, as you can see, there's an adequate scientific basis to justify something larger. And it does not permit any kind of commercial motivations in terms of the pursuit of this research. And again, it requires a prior assessment of the potential impacts on the environment. But again, there are limitations to what the CBD is likely to be able to do in this context. Again, its resolutions, as is true with the London Convention, are not legally binding on the parties. Second of all, quite frankly, the regime has been terribly ineffective in meeting its core objectives of stanching the loss of biodiversity, and one wonders if it has the capabilities of taking on an issue that is well outside of its primary purview. And then finally, any risk assessment that needs to be done in this context is likely to require a lot of resources on the part of individual countries, and that's been one of the greatest weaknesses of this regime to date, is effective monitoring of biodiversity trends, effective monitoring of potential threats, and integrated assessment. And that would be critical in this context. Now, a couple of other regimes that might be pertinent in the future, especially if we look to beyond research of carbon dioxide removal approaches to actual deployment of these technologies. One that's logical is obviously the Paris Agreement. if we were to go down the path of large-scale deployment of carbon dioxide removal, it would obviously be part of an integrated strategy to address climate change, which would include, on one leg of the stool, traditional mitigation efforts to reduce emissions and to increase energy efficiency. The second being adaptation responses to climate change, and perhaps the third being geoengineering responses to climate change, including carbon dioxide removal approaches. So to the extent that that's true, it would be logical for the Paris Agreement to be the primary institution to regulate these approaches and seek to integrate them into the other responses to climate change. And indeed, there are provisions of the Paris Agreement that would provide for some authority to be able to scrutinize the use of carbon dioxide removal approaches by the parties. The Paris Agreement clearly contemplates that carbon dioxide removal could be incorporated into the nationally determined contributions of the parties, because it defines, it says NDCs should utilize mitigation responses, and mitigation, at least in the Framework Convention, the parent agreement to the Paris Agreement, defines mitigation as both reducing emissions and enhancing sinks. And enhancing sinks means things that store carbon dioxide. So all of these CDR approaches would seem to fit comfortably into the definition of mitigation. But there are provisions of Paris that would allow scrutiny, I think, of CDR. One of them can be found in the preamble to the Paris Agreement that talks, that recognizes that, quote, parties may be affected not only by climate change, but also by the impacts of the measures that are taken in response to it. So clearly CDR would be a potential response to climate change, and thus it could come under the scrutiny of the parties to Paris. Moreover, there's some specific provisions that would be pertinent. Beyond this provision here, it talks about looking at the possible impacts of climate in terms of ecosystems, including oceans and biodiversity. And so by extension, we would look at not only the impacts of climate change, but also the impacts of response measures in the context of ecosystems and biodiversity, which would provide authority for the parties to be able to scrutinize any incorporation of carbon dioxide removal into the NDCs and the potential impact that it would have on humans as well as biodiversity. Moreover, the parties to the Framework Convention established a forum on the impact of the implementation of response measures, and this forum has been incorporated into the Paris Agreement. The committee meets twice annually to assess response measures, and it can also establish ad hoc technical expert groups. And I would suggest that this would provide the potential authority to establish an ad hoc technical expert group to assess the potential impacts of carbon dioxide removal approaches, again, on humans as well as on non-humans. And that would be salutary given some of the potential impacts that we're talking about here. And then finally, very briefly, other regimes might also be involved in the future. And it is likely that we would face a polycentric sort of environment in terms of regulation of these approaches. And in the case of biodiversity, I would argue that might be salutary, because some of the regimes that we're talking about might not have a lot of expertise in terms of biodiversity or as much concern about biodiversity as human impacts. And so some of these regimes might provide some of that necessary focus as well as necessary expertise. One that may be terribly pertinent in the future is the Biodiversity Beyond National Jurisdiction Treaty that's currently being developed under the United Nations Convention for the Law of the Sea. This treaty will ultimately include risk assessment requirements for activities that would occur on the high seas, which might include some of the activities, the carbon dioxide removal approaches that we're talking about here, including ocean iron fertilization and enhanced ocean alkalization. Moreover, this treaty likely will also include a transboundary environmental assessment requirement. And to the extent that some of these approaches would have impacts in the global commons or impact species in exclusive economic zones, which certainly could be the case in the two ocean-based approaches that we talked about here, this would provide a framework for assessing those approaches. Now, one of the things that I would suggest should be included in any of these assessments is also a basis for comparative risk assessment. One of the things that needs to be emphasized is that these CDR approaches clearly could have some potential negative impacts in terms of biodiversity, but we also know that unchecked climate change, as the IPCC has emphasized continuously, would also have incredibly negative impacts on biodiversity. So one of the things that we're going to need to do is to assess whether the risks of deploying these technologies is greater than unchecked climate change, or whether the combination of requiring increased reduction of emissions coupled with perhaps a smaller component of CDR would reduce risks to the point where they're more tenable than the status quo. That's going to require again, a lot of resources and sophisticated analysis, but it's probably something that we need to do at this point, given how perilously close we are to passing climatic thresholds that will have serious negative impacts in terms of species. Other regimes that also might potentially be pertinent in this context would include CAMLAR, the Convention for the Conservation of Antarctic Marine Living Resources, should ocean iron fertilization be one of the approaches that would deploy it at a large scale. Most of the opportunities for seeding the world's oceans with iron that would produce substantial increases of phytoplankton would be found in the Southern Ocean. But again, it could potentially have negative implications for some of the species that are regulated under CAMLAR. Other regimes would include fisheries agreements, given the potential impacts that would occur, including regional regimes, as well as potentially the Straddling Fish Stocks Convention, which includes provisions for assessing impacts on straddling stocks beyond fishing, which could include carbon dioxide removal technology deployment. And then finally, there are customary international law principles that would be pertinent in this case. One would be the no harm rule. If these activities were to be deployed in national jurisdictions, for example, or in exclusive economic zones, and they were to have impacts on the global commons, or in a transboundary context, the no harm rule could become pertinent in terms of assessing the use of due diligence, for example, and efforts to ameliorate potential negative impacts. And then finally, the precautionary principle. Though the precautionary principle could, of course, cut both ways. It could be argued that it would counsel in favor of very large, small-scale use of these technologies, given the unknowns of the risks that they might pose. But it could also be argued that given the risks that are posed by unchecked climate change, it would argue in favor of deploying those technologies at a very large scale. And that's an issue that would have to be resolved in individual regimes and in other political fora. So I'm going to stop there and simply emphasize that it's likely, given where we are in the climate sphere, that carbon dioxide removal approaches are going to be discussed far more in the upcoming decade, and likely to be deployed by a number of individual countries as they seek to meet their obligations under Paris. At that point, it's going to be important for us to look at the risks that these technologies might pose both to humans, but also in terms of biodiversity, with the goal of potentially fashioning a portfolio of these responses, all at a scale that minimize the risks to those interests, while at the same time helping us to effectuate the goal of buying time as we seek to decarbonize the world's economies. And with that, I will conclude and take any questions that you might have. Thank you very much.
Thank you very much, Will. That was a tremendous talk. That was incredibly clear in terms of laying out the options and excellent points. I especially appreciated the point about the comparative risk assessment, the risk of doing nothing or not taking these some type of CDR approaches. So we have a let's see, we have some questions. Let's see. So we've got first question in the queue from Volker. He was asking about in terms of at this point, we were actually decreasing greenhouse gas emissions due to the shelter in place and the response to the COVID crisis. To what extent has that been taken into models, and how much does that buy us any significant time?
Yeah, that's not likely. It's not likely to buy us significant time unless, of course, we're shut down for years on end, which is probably not likely given the economic implications. It certainly provides us with some evidence of what would happen if we started to decarbonize the world's economies, but it's likely that in a few months we'll be, back on track. And quite frankly, even if it were to buy us a year or two, we'd still pass critical thresholds, but simply pass those critical thresholds only a little longer down the path. So CDR is probably, no pun intended, baked into most of the models in terms of what needs to be done. The question is at what scale, and that to some degree is influenced by again how much we can effectuate demand response changes that bend the curve, and how much more quickly we could accelerate decarbonization through adoption of things such as renewables. And that's something that should always be emphasized. One of the worries that I have with carbon dioxide removal approaches is there's often a kind of a Manichaean sort of choice that are posed to people, which is unchecked climate change or really large-scale use of carbon dioxide removal or the other kind of geoengineering, solar radiation management. We don't want that to necessarily be the only options we talk about, right? The other option is far more aggressively ratcheting up use of renewables, and if we could do that, we could potentially substantially reduce the amount of CDR that we might have to use in the future, and that might be salutary given the uncertainties of what the impacts of some of these would be, both in terms of humans and in terms of biodiversity, as I talked about today.
Okay, let's see. We have another question from Dr. Chin, who says, "Thanks for the wonderful presentation. Compared to climate change, biodiversity and wildlife is somewhat marginalized. How do you think we could mainstream biodiversity and wildlife law besides connecting it with climate change?"
Yeah, that's a very difficult question. I mean, if you look at the Convention on Biological Diversity, and as I indicated before, kind of its abject failure to date, it's obvious that countries are not prioritizing wildlife to the extent that they need to, We've certainly tried to do things like provide realistic valuations of the values of ecosystem services, right? To try to kind of appeal to the most anthropogenic interests possible, recognizing that that might be politically the most palatable way to do this. But I don't think people have taken a lot of those very seriously. I think from a political standpoint, it's difficult to tangibly see those, as opposed to how we tangibly see putting up a new hotel on a coast, right? Or engaging in commerce on the sea, despite the impacts that it has. And so it's difficult to know how one can do that in a way that'll be effective. Certainly, some of the things that the CBD talks about at its core, if we could actually implement them, I think can make a big difference. For example, there's a mandate that there be cross-sectoral integration of biodiversity considerations into all decision making in a country, right? That's clearly not being done. In most cases, biodiversity is a consideration of environmental ministries that are often usually politically weak within a country, and other agencies don't view it as an important part of their priorities. And if that were to change, it could make a big difference. But that requires, political prioritizing that we don't see. And then we have obviously huge information shortfalls in terms of even monitoring species trends and identifying major threats and devoting the kind of resources that are necessary to address that. But despite that regime beseeching countries to do more in that context, we simply haven't seen it happening to date. So I have to say I fear I'm at a loss in terms of what we need to do at this point.
I smiled when you mentioned cross-sectoral approaches, because that is something that we've wrestled with in the Ramsar context, and there have been calls and exhortation for cross-sectoral approaches. And I mean, I'm involved with one research project where we're taking a look at one of the primary drivers of wetland loss historically has been agriculture, and to what extent has that actually, do the value of wetlands get taken into account in agricultural policy decisions? And we're trying to look for specific examples of where there is some. Give me one example of where a cross-sectoral approach has been implemented effectively, so perhaps we can use that as a model. But it's very challenging, and so there is, again, in the Ramsar context, the value of wetlands, economic and non-economic value of the ecosystem services is certainly promoted. One of the pushes, though, is for example, with the contributions of wetlands to DRR, to disaster risk reduction, but that also that has a linkage back to climate change, and so it may be that one of the keys to mainstreaming biodiversity and wildlife is trying to link it up to climate change to the extent we can. So let's see if there are any other questions.
Yes, can I ask question?
Yes. Oh, yes, please. Please go ahead.
Okay, thank you very much for the flow, and many thanks to Professor Will Burns. It was a very interesting presentation. And I have some few questions. The first one is about the challenges. I don't know if you have done also other research about the challenges of developing country to implement the CDR approach. As you know, developing countries are facing many challenges regarding technology. So in my opinion, I don't know if it could be easy for this country to implement this approach. Secondly, I have a question about the link between the CDR approach and the protocol, the Montreal protocol, because you talk about many regime, climate, CDB, Paris agreements. I want to know if there is a specific link between the CDR approach and the protocol of Montreal. And then I want to know also if the ocean iron fertilization, is it favorable to reduce plastic pollution in the oceans? This is just a very general question as you talk about the ocean iron fertilization. I'm very interested to know if there is a kind of link between oceans iron fertilization and the reduction of plastic pollution. Thank you very much.
Okay, I think I heard all three of the questions. I was getting some echo, so I apologize if I don't, if I didn't see all of them or hear all of them correctly. I think the first was talking about the challenge that developing countries face in terms of regulating CDR, and yes, that's certainly a concern that a lot of us have in this context. One of the things, this isn't exclusively in the context of biodiversity, but one of the concerns that we have in terms of BECCS and afforestation especially is that many developed countries that are going to may seek to meet parts of their NDCs by utilizing these technologies, and they may find that the best places to do that or to get the feedstocks for doing that are developing countries, especially extremely vulnerable countries, or quite frankly failed states where you just have to deal with elites and you can easily siphon off the resources that you need. So there's fears, for example, that if there's a need for large amounts of bioenergy feedstocks, we may go to countries in sub-Saharan Africa, for example, or in South America, and engage in activities that will prove wholly unsustainable and have negative impacts in terms of food prices, as we talked about for humans, but also in terms of biodiversity impacts. And there'll be very little capability of assessing the impacts, and maybe very little proclivity to do so, given the weak governance in those contexts. So it is something that we worry about. It's one of the reasons that I think there has to be an international framework in place that would provide some potential check on that. And so what some of these regimes are doing in terms of developing that framework, I think, is important as a potential backstop to whatever national regulations might be developed in this context. Second of all, in terms of the Montreal Protocol, when we look at the protocol, most of the time when we're talking about geoengineering, we see the protocol as being pertinent in the context of the other kind of geoengineering, which is solar radiation management. And the reason is that at least one of these approaches that's most talked about in this context is something called sulfur aerosol injection. The idea is to place large amounts of sulfur dioxide into the stratosphere, which will oxidize into sulfate particles that are highly reflective and will reflect a certain amount of incoming solar radiation back to space, which exerts a cooling impact, right? That's the approach most talked about. One of the potential negative impacts of doing that is that you would provide huge additional platforms for ozone depleting substances to engage in the kind of catalytic processes that break down the ozone layer. And so some studies have said that if you were to deploy this technology at a really large scale, you might delay the recovery of the ozone layer, which is being effectuated through Montreal, by 30 to 70 years, right? So there's certainly been arguments that if you were to deploy this technology or contemplate deploying this technology, that the Montreal Protocol would potentially have a voice in this. But I think in the context of carbon dioxide removal, we haven't talked much about Montreal in terms of impacts that they would potentially regulate. And then finally, in terms of ocean iron fertilization, I don't think there's any nexus in terms of plastic pollution in the sense that what we're talking about is the addition of iron filings. And I don't think anybody believes that that would have any impact in terms of plastics loads, unless you're thinking of a nexus that's different than the one that I would think of in this context.
No, I don't have a clear idea about that. So this is why I asked the question. Thank you very much for your answers. Thank you.
Sure.
I don't see any other questions. And it looks like we may have lost Roy. Roy,
Yeah.
are you on?
Yes.
There he is.
Can you hear me? Sorry. Thanks, Aaron, for jumping in there, and thank you, Will, so much for joining us. That was a great talk and great discussion.